the liabilities for the people, the procedural law works out the remedy as to how one has to have his right or liability is to be enforced. With this, actually, I start this. ಕನ್ನಡದಲ್ಲೇ ಶುರು ಮಾಡ್ತೀನಿ. ಅಫ್ಕೋರ್ಸ್ ಇಂಗ್ಲೀಷಲ್ಲೂ ಶುರು ಮಾಡಿದೆ, ಕನ್ನಡದಲ್ಲೂ ಮಾಡ್ತೀನಿ, ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. ಬಿಕಾಸ್ ಆಫ್ ಮೈ ಆ್ಯಂಡ್ ಎನಿಥಿಂಗ್ ಈಸ್ ದೇರ್, ಪ್ಲೀಸ್ have an interaction. Let us not have it as a one-way traffic. And ಈ ಒಂದು ದಿವಾಣಿ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ ಬಗ್ಗೆ ನಾವು ತಗೊಂಡಾಗ, ಏನು ದಿವಾಣಿ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ, ಇದರ ವ್ಯಾಪ್ತಿ ಏನು ಮತ್ತು ಇದು ಯಾವ ರೀತಿ ನಮಗೆ ಒಂದು ದೈನಂದಿನ ಕಾರ್ಯಾಚರಣೆಗೆ ಉಪಯೋಗ ಅನ್ನೋದು ಬಹಳ ಮುಖ್ಯವಾದಂಥ ವಿಷಯ. ಸಿವಿಲ್ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ನಾವು ಯಾವುದೇ ಒಂದು ವ್ಯಾಜ್ಯವನ್ನು ಹೂಡಬೇಕಾದ್ರೆ ಅಥವಾ ವ್ಯಾಜ್ಯವನ್ನು ನಡೆಸಬೇಕಾದ್ರೆ ಅಥವಾ ವ್ಯಾಜ್ಯವನ್ನು ತೀರ್ಮಾನ ಮಾಡಬೇಕಾದ್ರೆ ಬಹಳ ಮುಖ್ಯವಾಗಿ ಬೇಕಾದದ್ದು ದಿವಾಣಿ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ, otherwise Civil Procedure Code. Civil Procedure Code is followed more or less in civil courts rather than criminal courts. ಸಿವಿಲ್ ಕೋರ್ಟ್ಗಳಿಗೆ ಈ ದಿವಾಣಿ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ ಅನ್ನೋದು ಒಂದು ಬೈಬಲ್ ಇದ್ದ ಹಾಗೆ, ಅಥವಾ ಭಗವದ್ಗೀತೆ ಇದ್ದ ಹಾಗೆ, ಅಥವಾ ಕುರಾನ್ ಇದ್ದ ಹಾಗೆ. ಯಾಕಂದರೆ ನಾವು ಈ ಒಂದು ಇದರಲ್ಲಿ ಒಂದೇ ಒಂದು ಇದನ್ನು ಹೇಳಿಬಿಟ್ರು ಅದರಿಂದ ನಮಗೆ ಅಂತ ಬೇಡ. ಈ 3 ಗ್ರಂಥಗಳನ್ನು ನಾವು ಎಷ್ಟು ಧಾರ್ಮಿಕವಾಗಿ ಪರಿಗಣಿಸ್ತೀವೋ ಅದೇ ರೀತಿ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಅಥವಾ ದಿವಾಣಿ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ ಅನ್ನೋದು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಬೇಕಾದಂತಹ ಒಂದು ಪ್ರೊಸೀಜರಲ್ ಲಾ ಅಥವಾ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ. ತಮಗೆಲ್ಲರಿಗೂ ಗೊತ್ತಿರೋ ಹಾಗೆ ನಾವು ಇವಾಗ ಹೊಂದಿರುವಂತಹ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ 1908ರಲ್ಲಿ ಜಾರಿಗೆ ಬಂತು. ಈ ಜಾರಿಗೆ ಬಂದಿದ್ದ, ಅಫ್ಕೋರ್ಸ್ ಇದು ಐ ಆಮ್ ಗಿವಿಂಗ್ ಓನ್ಲಿ ಎ ಸ್ಮಾಲ್ ಹಿಸ್ಟಾರಿಕಲ್ ಬ್ಯಾಕ್ಗ್ರೌಂಡ್. ಆ್ಯಂಡ್ ಈ ಜಾರಿಗೆ ಬಂದ ನಂತರ ಇದರ ಪೂರ್ವದಲ್ಲಿ ಯಾವುದಾದ್ರೂ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆಗಳು ಇತ್ತ ಅಥವಾ ಇರಲಿಲ್ವ ಅನ್ನೋದು ಒಂದು ವಿಷಯ ಬಹಳ ಮುಖ್ಯವಾದದ್ದು. ಯಾವುದೇ ಒಂದು ಸಮಾಜದಲ್ಲಿ ಒಂದು ವ್ಯಾಜ್ಯವನ್ನು ಇತ್ಯರ್ಥ ಮಾಡಬೇಕಾದ್ರೆ ಒಂದು ರೀತಿ ರಿವಾಜುಗಳು ಬೇಕಾಗತ್ತೆ. ಈ ರೀತಿ ರಿವಾಜುಗಳು ಇಲ್ಲದೇ ಇತ್ಯರ್ಥ ಮಾಡೋಕ್ಕೆ ಹೋದರೆ ಅದು ಆರ್ಬಿಟ್ರರಿನೆಸ್ಗೆ ಸ್ಥಳ ಕೊಡುತ್ತೆ. ಆದ ಕಾರಣ ಪ್ರತಿಯೊಂದು, ಇನ್ಫ್ಯಾಕ್ಟ್ ನಮ್ಮ ಭಾರತದಲ್ಲಿ ನಾವು ತಗೊಂಡಾಗ ಏನ್ಷಿಯಂಟ್ ಟೈಮ್ ಅಂತ ನಾವು ಯಾವುದನ್ನು ಹೇಳ್ತೀವಿ ಅಥವಾ ಯಾವುದನ್ನು ಸನಾತನ ಧರ್ಮ ಅಂತ ಕೆಲವರು ಹೇಳ್ತಾರೋ, ಆವಾಗಲೂ ನಾರದ ಸ್ಮೃತಿ, ಬೃಹಸ್ಪತಿ ಸ್ಮೃತಿ ಮುಂತಾದಂತಹ ಸ್ಮೃತಿಗಳು ಇತ್ತು. ಆ ಸ್ಮೃತಿಗಳಲ್ಲಿ ವಾದಪತ್ರ ಮತ್ತು ಈ ಕೇಸುಗಳನ್ನ ಹೇಗೆ ನಡೆಸಬೇಕು ಅನ್ನೋ ಒಂದು ಅಂಶ ಇತ್ತು. ಆದರೆ ಇವಾಗಿನ ಒಂದು ಕೂಲಂಕುಷವಾದಂತಹ ಮಾಡರ್ನ್ ಸೈಂಟಿಫಿಕ್ ಟೆಕ್ನಾಲಜಿ ಆಸ್ಪೆಕ್ಟು ಇರಲಿಲ್ಲ. ಇದಾದ ನಂತರ ಕಾಲಾನುಕಾಲಕ್ಕೆ ನಾವು ನಮ್ಮ ದೇಶದ ಚರಿತ್ರೆಯನ್ನು ನೋಡಿದಾಗ ಬೇರೆಯವರು ಸಹ ನಮ್ಮ ದೇಶದಲ್ಲಿ ಆಡಳಿತಕ್ಕೆ ಬಂದರು. ಈ ಸಂದರ್ಭದಲ್ಲಿ ಅವರದೇ ಆದಂತಹ ಒಂದು ಈ ನಿಯಮಗಳನ್ನು ಅಳವಡಿಸ್ಕೊಳ್ಳಾಯಿತು. ದಿವಾಣಿ ಕೋರ್ಟುಗಳು, ದಿವಾಣಿ ನ್ಯಾಯಾಲಯಗಳು ಅಂತ ಎಲ್ಲ ಶುರುವಾಯಿತು. ಈ ಇದು ವ್ಯವಸ್ಥೆ ಮುಂದುವರೆದ ನಂತರ 1600ರಲ್ಲಿ ಈಸ್ಟ್ ಇಂಡಿಯಾ ಕಂಪ್ನಿಯವರು ತಮ್ಮದೇ ಆದಂತಹ ಒಂದು ವ್ಯಾಪಾರ ಸಂಸ್ಥೆಗಳನ್ನು ಭಾರತದಲ್ಲಿ ಶುರು ಮಾಡಿದ್ರು. ಆದರೆ ಕಾಲಕ್ರಮೇಣ ವ್ಯಾಪಾರಿಗಳಾಗಿ ಬಂದವರು ಇಲ್ಲೇನೇ ಆಡಳಿತಕ್ಕೂ ತಗೊಂಡು, ಈ ಆಡಳಿತಕ್ಕೆ ತಗೊಂಡಾಗ ನಮ್ಮದೇ ಒಂದು ನ್ಯಾಯ ಪದ್ಧತಿ, ಬ್ರಿಟಿಷ್ನವ್ರದ್ದೇ ಒಂದು ನ್ಯಾಯ ಪದ್ಧತಿ ಎನ್ನುವುದು ಶುರುವಾಯಿತು. ಇದಾದ ನಂತರ 1850ರಲ್ಲಿ ಮೊದಲನೆಯ ದಿವಾಣಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಪ್ರಾರಂಭ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಬಾಂಬೆ ಪ್ರೆಸಿಡೆನ್ಸಿ, ಕಲ್ಕಟಾ ಪ್ರೆಸಿಡೆನ್ಸಿ, ಮೆಡ್ರಾಸ್ ಪ್ರೆಸಿಡೆನ್ಸಿನಲ್ಲಿ ಶುರು ಮಾಡಿದ್ರು. ಈ ದಿವಾಣಿ ಅಂಥ ಸಮಯದಲ್ಲಿ ನಮಗೆ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಅನ್ನೋದನ್ನು ಕ್ರೋಢೀಕರಿಸಿ ಒಂದು ಮಾಡಿದ್ರು. 1908ರಲ್ಲಿ ಜಾರಿಗೆ ಬಂದಂತಹ ಈ ಇತ್ತೀಚಿನ ದಿವಾಣಿ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆ ಅಥವಾ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್, ಅದರಲ್ಲಿ ಸುಮಾರು 158 ಸೆಕ್ಷನ್ಗಳಿದೆ. ಇದಲ್ಲದೇ ಸುಮಾರು ಒಂದು ಶೆಡ್ಯೂಲ್ ಇದೆ. ಈ ಒಂದು ಶೆಡ್ಯೂಲು ಅದಕ್ಕೆ ಮೊದಲಿದ್ದಂತಹ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ನಲ್ಲಿ 3 ಶೆಡ್ಯೂಲ್ಗಳಿತ್ತು, ಸುಮಾರು 300 ಸೆಕ್ಷನ್ಗಳಿತ್ತು. ಆದರೆ ಅವುಗಳನ್ನೆಲ್ಲ ಕ್ರೋಢೀಕರಿಸಿ 1908ರಲ್ಲಿ 158 ಸೆಕ್ಷನ್ಗಳನ್ನು ಮಾಡಿದ್ರು. ಅದರಲ್ಲೂ ಕೆಲವು ಸೆಕ್ಷನ್ಗಳು ಇವಾಗ ಡಿಲೀಟ್ ಆಗಿದೆ, ಸಾಂದರ್ಭಿಕವಾಗಿ ಇಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಈ ಒಂದು ವಿಷಯವನ್ನು ನಾವು ಗಣನೆಗೆ ತಗೋಬೇಕಾಗತ್ತೆ. ಇಂತಹ ಒಂದು ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಪ್ರತಿಯೊಬ್ಬ ನ್ಯಾಯವಾದಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ನಲ್ಲಿ ಹೋಗಿದ ತಕ್ಷಣ ಬರುವಂತಹ ಒಂದು ಪುಸ್ತಕ ಅಂದರೆ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್. ಅದು ಬಿಟ್ಟರೆ ಬೇರೆ ರೀತಿಯಲ್ಲಿ ಹೋಗೋಂಗೆ ಇಲ್ಲ, ಹಾಗಾಗಿದೆ. ಈ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ನಿಮ್ಮೆಲ್ರಿಗೂ ಈಗಾಗಲೇ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ನ ವ್ಯಾಪ್ತಿ ಏನು, ಅದರಲ್ಲಿ ಯಾವ ರೀತಿ ದಾವೆಯನ್ನು ಹೂಡ್ತೀರಿ, ಯಾವ ರೀತಿ ದಾವೆ ಹೂಡಿದ ನಂತರ ಈ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್, ಕೆಲವು ಕಡೆ ಕೈಫಿಯತ್ ಅಂತಾರೆ, ಅಂಥದ್ದನ್ನು ಸಲ್ಲಿಸೋದು, ಆನಂತರ ಈ ವಿವಾದಾಂಶಗಳು ಅಥವಾ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡೋದು, ಇದು ಕಾಮನ್ನಾಗಿ ನಡೆದು ಬಂದಿರುವಂತಹ ಒಂದು ಪದ್ಧತಿ. ಅದರಿಂದ ಈ ಪದ್ಧತಿ ಇರಬೇಕಾದ್ರೆ ಇದ್ರ ಬಗ್ಗೆ ಏನು ಮಾತಾಡ್ತಾರೆ ಇವರು, ಈ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಬಗ್ಗೆ ಎಲ್ರಿಗೂ ಗೊತ್ತಿರೋ ವಿಷಯನೇ ಇದು ನಮ್ಮಗಳಿಗೆ. ಇದು ಎಂಥ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಇದು? ಆರ್ಡರ್ 7 ತೆಗೆದರೆ ಯಾವ ರೀತಿ ಇರಬೇಕು, ವಾದಪತ್ರ ಪ್ಲೇಂಟ್ ಅನ್ನೋದಿದೆ. ಆರ್ಡರ್ 8 ತೆಗೆದರೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ಇದೆ. ಆರ್ಡರ್ 10 ರೆಡ್ ವಿತ್ ಆರ್ಡರ್ 14 ತಗೊಂಡ್ರೆ ಇಶ್ಯೂಸ್ ಅಂತ ಇದೆ. ಆನಂತರ ಸಮನಿಂಗ್ ಆಫ್ ದಿ ವಿಟ್ನೆಸ್ಸು, ಆಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್, ಜಡ್ಜ್ಮೆಂಟ್. ಆಮೇಲೆ ಜಾರಿ ಆಗದೇ ಇದ್ದರೆ ಜಡ್ಜ್ಮೆಂಟ್ ತೀರ್ಪಿನ ಪ್ರಕಾರ ನಡ್ಕೊಳ್ಳದೇ ಇದ್ದರೆ ಅಮಲು ಜಾರಿ ತಗೊಳ್ಳೋದು, ಅಪೀಲುಗಳು, ಇದೆಲ್ಲ ಕಾಮನ್ನು. ಇದರ ಬಗ್ಗೆ ಎಂತಹ ವಿಷಯ ಇದು ತಿಳಿಯುವಂಥದ್ದು, ಇದರಲ್ಲಿ ಏನಿದೆ ಅನ್ನೋ ಒಂದು ಕುತೂಹಲನೂ ಬರುತ್ತೆ. ಕೆಲವು ಸರ್ತಿ ಕುತೂಹಲಕ್ಕಿಂತ ಇದೆಂಥ ವಿಷಯ ಬರಡು ವಿಷಯ ಅಂತ ತಗೊಂಡಿದ್ದಾರಪ್ಪ ಇವರು ಅಂತ ಒಂದು ಅಭಿಪ್ರಾಯನೂ ಬರುತ್ತೆ. 1908ರಲ್ಲಿ ಸ್ಥಾಪಿತವಾದಂತಹ ಅಥವಾ ರಚಿತವಾದಂತಹ ಈ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಕಾಲಕ್ಕೆ ಅನೇಕ ತಿದ್ದುಪಡಿಗಳನ್ನು ಹೊಂದಿದೆ. ಈ ತಿದ್ದುಪಡಿಗಳಲ್ಲಿ 1973-74 ಆ ಸಮಯದಲ್ಲಿ ಆದಂತಹ ತಿದ್ದುಪಡಿಗಳು ಬಹಳ ಮಹತ್ವವಾದ ತಿದ್ದುಪಡಿಗಳು ಅಂತಲೇ ಹೇಳ್ಬೋದು. ಯಾಕಂದರೆ 1908ರಲ್ಲಿ ಆದಂತಹ ಕಾಯ್ದೆಗೆ ಯಾವುದೇ ಒಂದು ತಿದ್ದುಪಡಿಯನ್ನು ಆ ಒಂದು ರೀತಿಯಲ್ಲಿ ತಂದಿರಲಿಲ್ಲ. ಆದರೆ 1977ರಲ್ಲಿ ಆದಂತಹ ತಿದ್ದುಪಡಿ ನಂತರ ಪುನಃ ಏನಾದರೂ ತಿದ್ದುಪಡಿ ಆಯಿತಾ ಅನ್ನೋದು ಒಂದು ಪ್ರಶ್ನೆ ಬರುತ್ತೆ. ಈ ಪ್ರಶ್ನೆ ಬಂದಾಗ 1999ರಲ್ಲಿ ಪುನಃ ತಿದ್ದುಪಡಿ ಆಯಿತು. ಈ ಕಾನೂನು ಅನ್ನೋದು ನಿಂತ ನೀರಲ್ಲ. ಈ ಒಂದು ಸಮಾಜದಲ್ಲಿ ಕಾನೂನು, ಸಮಾಜ ಅನ್ನೋದು ಹರಿಯುವ ನೀರಿದ್ದಂಗೆ. ಈ ಈ ಹರಿಯುವ ನೀರಿನಲ್ಲಿ ಕಾನೂನು ಬರೀ ನಿಂತು ನೀರಾಗಿಬಿಟ್ರೆ ಅದು ಬಹಳ ದುಷ್ಪರಿಣಾಮಗಳನ್ನ ಬೀಳುತ್ತೆ. ಇಟ್ ಈಸ್ ಗೋಯಿಂಗ್ ಟು ಕ್ರಿಯೇಟ್ ಹ್ಯಾವಕ್ in a society if it becomes a stagnant water, and the social changes do take place, and law also has to go along with the social changes. That's what we call social lag, socio-legal lag ಅಂತ ಕರಿತೀವಿ. ಇಂಥ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ 1999ರಲ್ಲಿ ಆದಂತಹ ತಿದ್ದುಪಡಿ ವಿಷಯವಾಗಿ ಚರ್ಚೆಗೂ ಬಂತು. ಆವಾಗಿನ ಪಾರ್ಲಿಮೆಂಟ್ನಲ್ಲಿದ್ದವರು ಸರಿಯಾಗಿ ವಿಷಯಗಳನ್ನು ಪರಿಗಣನೆಗೆ ತೆಗೆದುಕೊಳ್ಳದೆ ಈ ತಿದ್ದುಪಡಿಗಳನ್ನು ಮಾಡಿರೋದ್ರಿಂದ ಈ ಪ್ರಕ್ರಿಯೆ ಜನಗಳಿಗೆ ತೊಂದರೆಯನ್ನು ಉಂಟಾಗತ್ತೆ ಅನ್ನೋ ಒಂದು ಕೋಲಾಹಲನೂ ಶುರುವಾಯಿತು. ಈ ಕೋಲಾಹಲದ ನಂತರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ಈ ವಿಷಯವನ್ನು ಪರಿಗಣನೆಗೆ ತಗೊಂಡ್ರು. ಸೇಲಂ ಅಡ್ವೊಕೇಟ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ಆರ್ ಸೇಲಂ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಕೇಸ್ ಬಹಳ ಮುಖ್ಯವಾದಂಥ ಒಂದು ಕೇಸು. ಈ ಕೇಸ್ನಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು ಫಸ್ಟ್ ಟೈಮ್ ಈ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಇದ್ರ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ಮಾಡಿ ಆನಂತರ ಕೆಲವು ರೀತಿ ರಿವಾಜುಗಳನ್ನ ನಿಯಮಗಳನ್ನ ಹಾಕ್ಕೊಟ್ರು. ಆನಂತರ 1912ರಲ್ಲಿ ಪುನಃ ಇದು ತಿದ್ದುಪಡಿ ಆಯಿತು. ಈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಯಾವ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದರೋ ಆ ಡೈರೆಕ್ಷನ್ಗಳನ್ನು ಅಳವಡಿಸಿ ತಿದ್ದುಪಡಿ ಮಾಡಿದ್ದಾರೆ. ಇದಿಷ್ಟು ಒಂದು ವಿಷಯ. ಆದರೆ ನಾನು ನಿಮಗೆ ಹೇಳ್ದಂಗೆ ಸೊಸೈಟಿ ಅಂದರೆ ಸಮಾಜದಲ್ಲಿ ಅನೇಕ ರೀತಿಯಾದಂತಹ ಡಿಸಾರ್ಮೋನಿಗಳು ಇರುತ್ತೆ. ಇಂತಹ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ಬೇರೆಯ ರಾಷ್ಟ್ರಗಳಿಂದ ಅಥವಾ ಬೇರೆಯ ರಾಜ್ಯಗಳಿಂದ ಅಥವಾ ಬೇರೆ ವೃತ್ತಿಯಿಂದ ಬಂದವರು ಕೋರ್ಟ್ನಲ್ಲಿ ಒಂದು ಕೇಸ್ ಹಾಕಿಬಿಟ್ಟು ಕೊನೆಯವರೆಗೂ ಕಾಯೋದಕ್ಕಾಗೋಲ್ಲ. ಎಸ್ಪೆಷಲಿ ಕಮರ್ಷಿಯಲ್ ವರ್ಲ್ಡ್ ಈಸ್ ಚೇಂಜಿಂಗ್ ಡೇ ಟು ಡೇ. ದಿ ವಾಣಿಜ್ಯ ಇದರಲ್ಲಿರೋರು ಅವರು ವೃತ್ತಿಯನ್ನು ಬಿಟ್ಟು ಕೋರ್ಟಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಸಮಯವನ್ನು ಹಾಳು ಮಾಡಿ ಅವರ ವೃತ್ತಿ ಏನಪ್ಪ ಅಂದರೆ ನಮ್ಮ ಮೂಲ ವೃತ್ತಿ ಬಿಟ್ಟು ಕೋರ್ಟ್ ವೃತ್ತಿನೇ ಆಗೋಯಿತು, ವಿ ಹ್ಯಾವ್ ಬಿಕಮ್ ಕೋರ್ಟ್ ಬರ್ಡ್ಸ್ ಅನ್ನೋಂಗೆ ಆಗಬಾರ್ದು ಅನ್ನೋ ಒಂದು ಉದ್ದೇಶದಿಂದ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ಸ್ ಆ್ಯಕ್ಟ್ ಅಂತ ಒಂದು ಹೊಸ ಕಾನೂನನ್ನು ಮಾಡಿದ್ರು. ಈ ಹೊಸ ಕಾನೂನು ಮಾಡಿದಾಗ ಈ ಹಳೆ ಕಾನೂನಿನ ಪದ್ಧತಿ ಪ್ರಕ್ರಿಯೆಯೇ ಹೊಸ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹೊಸ ಕಾನೂನಿಗೆ ಅಳವಡಿಸಿದ್ರೆ ಏನೂ ಬದಲಾವಣೆ ಇರುವುದಿಲ್ಲ. ಈ ಒಂದು ವಿಷಯದಲ್ಲಿ CPCಯ ಕೆಲವು ಭಾಗಗಳನ್ನ ಈ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ಸ್ ಭಾಗಕ್ಕೆ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ, ಅಥವಾ ಅಪ್ಲೈ ಆದ್ರೂ ಅವು ಯಾವ ರೀತಿ ಅಪ್ಲೈ ಆಗಬೇಕು ಅನ್ನೋ ಒಂದು ವ್ಯವಸ್ಥೆಯನ್ನು ಮಾಡಿದ್ರು. ಈ ಎಲ್ಲ ವಿಷಯಗಳನ್ನು ಯಾಕೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದರೆ CPC ಅನ್ನೋದು ನಿಂತ ನೀರಲ್ಲ, ಅಥವಾ ಅದನ್ನು ನಾವು ನಮ್ಮ ಮುತ್ತಜ್ಜನ ಕಾಲದಲ್ಲಿ ನಾವು ಹೀಗೆ ಓದಿದ್ವಿ ಅದನ್ನು ಇವಾಗಲೂ ಹೀಗೆ ಮಾಡಬೇಕು ಅನ್ನೋ ಒಂದು ನಿಯಮ ಇಟ್ಕೋಬಾರ್ದು, ಎಸ್ಪೆಷಲಿ ಯಂಗ್ಸ್ಟರ್ಸ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ಐ ರಿಮೆಂಬರ್ ಒನ್ anecdote, and I don't remember the name of the person who was an advocate in that case. That particular person ಅವ್ರು ಏನು ಮಾಡಿದ್ರು, ಭಾಳಷ್ಟು ಹಿರಿಯ ವಕೀಲರಾಗಿದ್ದರು. ಮಗನ್ನ ಆವಾಗಿನ ಕಾಲಕ್ಕೆ, ಇವಾಗಿನ ಕಾಲಕ್ಕಲ್ಲ, ಆವಾಗಿನ ಕಾಲಕ್ಕೆ ಇಂಗ್ಲೆಂಡ್ಗೂ ಕಳಿಸಿ ಅಲ್ಲಿ ಬ್ಯಾರೆಟ್ ಲಾನು ಮಾಡಿಸಿ ಇವರು ಬಂದರು. ಆದರೆ ಕೋರ್ಟ್ಗೆ ಇವರೇ ಹೋಗ್ತಾಯಿದ್ರು, ಇವರು ನಡೀತು. ಈ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ಒಂದು ದಿವಸ ಇವರು ಕೋರ್ಟ್ಗೆ ಹೋಗೋಕ್ಕೆ ಆಗಲಿಲ್ಲ. ಆಗ ತಮ್ಮ ಮಗನ್ನ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಒಂದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡು ಬಾ, ನಮ್ಮಪ್ಪನ ತಿಥಿ ಇದೆ ಇವತ್ತು ಅಂತ ಹೇಳಿದ್ರು. ಈ ಮನುಷ್ಯ ಹೋದ. ಕೋರ್ಟ್ನಲ್ಲಿ ನ್ಯಾಯಾಧೀಶರು, ಏನು ರೀ ಹಳೆಯ ಕೇಸು, ಇಷ್ಟು ವರ್ಷದ ಕೇಸ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಿ, ಇವತ್ತು ಟೈಮ್ ಕೇಳ್ತಿದ್ದೀರಿ, ಕೊಡೋಕ್ಕಾಗೋದಿಲ್ಲ ಸರಿ, ಈ ಹುಡುಗ ಏನು ಮಾಡ್ದೆ, ಆಯಿತು ನೀವು ಟೈಮ್ ಕೊಡೋಕ್ಕಾಗಲಿಲ್ಲ ಅಂದರೆ ಮಧ್ಯಾಹ್ನ ಹಾಕ್ಕೊಳ್ಳಿ, ನಾನು ನಡೆಸ್ತೀನಿ. ಸರಿ, ನ್ಯಾಯಾಧೀಶರು ಭಾಳ ಸಂತೋಷ ಆಯಿತು, ಪರವಾಗಿಲ್ಲ, ಇವ್ರ ತಂದೆ ಬಂದಿದ್ದರೆ ನಡೆಸ್ತಾ ಇರಲಿಲ್ಲ, ಈ ಹುಡುಗ ಬಂದು ನಡೆಸ್ತಾ ಇದ್ದಾನಲ್ಲ ಅಂತ. ಸರಿ, ಮಧ್ಯಾಹ್ನ ಇಟ್ಟರು. ಮಧ್ಯಾಹ್ನ ಇಟ್ಟ ಮೇಲೆ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಕೂತ್ಕೊಂಡು ಓದ್ದ. ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆಗೆ ಬಂದ, ಕೋರ್ಟ್ನಲ್ಲಿ ಹೇಳ್ದ, ಕೋರ್ಟ್ ತೀರ್ಮಾನ ಕೊಟ್ಟು ಕೇಸನ್ನು ಇತ್ಯರ್ಥ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡ್ತು. ಮನೆಗೆ ಬಂದ, ತಂದೆ ಕೇಳಿದ್ರು ಏನಪ್ಪ ಮಾಡಿದೆ ಅಂತ. ಕೇಳಿದ್ರೆ ಇವನು ಹೇಳ್ದ, ಇಲ್ಲ ಅವನು ಯಾವನೋ ಮೂರ್ಖ ಇಷ್ಟು ವರ್ಷ ಇಟ್ಕೊಂಡಿದ್ದ ಈ ಕೇಸನ್ನ, ಇದನ್ನು 5 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸೋವಂಥ ಕೇಸನ್ನು ಇಷ್ಟು ವರ್ಷ ಎಳೆದಿದ್ದು, ಆದ್ದರಿಂದ ನಾನು 5 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸ್ಬಿಟ್ಟೆ ನೋಡು ಅಂತ ಹೇಳ್ದ. ತಂದೆ ಹೇಳಿದ್ರು, ಹೌದಪ್ಪ, ನಾನು ನಿನ್ನ ಬ್ಯಾರೆಟ್ಲ ಓದೋದಕ್ಕೆ ಇಲ್ಲಿಂದ ದುಡ್ಡು ಕೊಟ್ಟು ಕಳಿಸಿದ್ದು ಈ ಕೇಸಿನ ದುಡ್ಡಿಂದಾನೆ, ಅವತ್ತು ನಾನು ಅಂತ ಹೇಳಿದ್ದು ಮಾಡು, ಆ ಥರ ಆಗಿಬಿಡುತ್ತೆ. ಆ ಥರ ಆಗಬಾರ್ದು ಅನ್ನೋ ಒಂದು ಉದ್ದೇಶದಿಂದ ಈ ಒಂದು ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡನ್ನು ಅಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಈಗ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ನಲ್ಲಿ ಮೊದಲು ಅಂದರೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಬೇಕು ಅಂದರೆ ಅದಕ್ಕೇನು ಕಾಲ ಮಿತಿನೇ ಇರಲಿಲ್ಲ. ಸ್ವಾಮಿ, ನಮಗೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಯಾರು ಮಾಡ್ತಾಯಿದ್ದೀವಿ, ಅಲ್ಲಿ ಬಂದಿದೆ, ಇಲ್ಲಿ ಬಂದಿದೆ, ಇವತ್ತು ಬರೆದಿದ್ದೀವಿ, ಪೂರ್ಣ ಇದಾಗಿಲ್ಲ ಅನ್ನೋ ಒಂದು ಕಾಲ ನೆಪಗಳು, ಕುಂಟು ನೆಪಗಳು ಎಲ್ಲ ಇರ್ತಿತ್ತು. ಕುಂಟು ನೆಪ ಅಂತ ನಾನು ಹೇಳೋಕ್ಕೂ ಆಗೋದಿಲ್ಲ, ಯಾಕೆಂದರೆ ನಾನು ಒಬ್ಬ ವಕೀಲ ಇವಾಗ. ಆದರೆ ಈ ಒಂದು ನೆಪ ಹೂಡೋದ್ರಿಂದ ಕಾಲ ಮುಂದೋಗ್ತಾ ಇದ್ವಿ. ಆದರೆ ಇವಾಗ ಏನು ಮಾಡಿದ್ದಾರೆ, CPCನಲ್ಲಿ ಸಮನ್ಸ್ ಜಾರಿಯಾದ 30 ದಿವಸದೊಳಗೆ ನೀನು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಬೇಕು. ಇದಾದ ನಂತರ ಈ ಕೋರ್ಟ್ನವರು 60 ದಿವಸ ಕಾಲ ಕೊಡ್ಬೋದು. ಆ ಕಾಲ ಕೊಡೋದಕ್ಕೆ ಕಾರಣ ಕೊಡಬೇಕು, ಕಾರಣ ಕೊಡದೇನೆ ಕಾಲ ಕೊಡೋಂಗಿಲ್ಲ ಅಂತ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಎಷ್ಟು ಕೋರ್ಟ್ನವ್ರು ಕಾಲ ಕೊಡ್ತಾರೆ, ಎಷ್ಟು ಕೋರ್ಟ್ನವ್ರು ಕಾರಣ ಕೊಡ್ತಾರೆ, ಕಾರಣ ಕೊಡೋದಿಲ್ಲ ಅನ್ನೋದು ಅದು ಬೇರೆ ವಿಷಯ. ಬಟ್ ಕಾನೂನು ಇರೋದು ಬುಕ್ ಇನ್ ಟೆಕ್ಸ್ಟ್ ಆ್ಯಂಡ್ ಬುಕ್ ಇನ್ ಕಾಂಟೆಕ್ಸ್ಟ್ ಆರ್ ಡಿಫ್ರೆಂಟ್. And book in text always says what is the law, but book in context thinks about how things are happening in this society. ಇದರಿಂದ ಟೈಮ್ ಕೊಡ್ತಾರೆ, ಹಾಕ್ತೀವಿ. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ ನಂತರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟಲ್ಲಿ ಹೇಗಿರಬೇಕು, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟು ವಾದಪತ್ರ ಹೇಗಿರಬೇಕು, ಇದೆಲ್ಲ ನಿಮಗೆ ಪೂರ್ಣ ಗೊತ್ತಿದೆ. ಅಫ್ಕೋರ್ಸ್ ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ದಿ ಯಂಗರ್ ಜನರೇಷನ್ ಐ ಮೇ ಹ್ಯಾವ್ ಟು ರಿಪೀಟ್. ಆ್ಯಂಡ್ ಈ ಒಂದು ಉದ್ದೇಶದಿಂದ ನನಗೆ ಕೊಟ್ಟಿರುವಂತಹ ಈ ಕಾಲಾವಧಿ ಐ ಥಿಂಕ್ ಅಪ್ ಟು 2 ಗಂಟೆ ಅಂತ ಹಾಕಿದ್ದಾರೆ, 1.5 ಗಂಟೆ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಈಗಾಗಲೇ 11 ಗಂಟೆ ಆಗೋಗಿದೆ, 1 ಅವರ್ ಲೇಟ್ ನಾವು. ಐ ಡೋಂಟ್ ಮೈಂಡ್ ಈ 2 ಗಂಟೆ ಅಥವಾ 2.5 ಗಂಟೆ ಕಾಲದಲ್ಲಿ 2 ಭಾಗಗಳಾಗಿ ಮಾಡೋದಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. ಮೊದಲನೇದು, what is actually the law in the text as we have to follow in these courts. For the understanding of my junior friends, because this is one of the workshop which is meant for the juniors to equip themselves for the future life. As far as the seniors are concerned, I am sure all of us have actually traveled a lot, and whatever is left over is a grace period for us. But for youngsters, it is not so. You have got life to see, life to entertain, life to enjoy. And ಈ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ನೀವುಗಳು ಹೊಸ ಕಾನೂನನ್ನು, ಹೊಸ ರೀತಿಗಳನ್ನು ತಿಳ್ಕೋಬೇಕಾಗತ್ತೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಶೇಕ್ಸ್ಪಿಯರ್ ಒಂದು ಕಡೆ ಅವನ ಒಂದು ನಾಟಕದಲ್ಲಿ ಹೇಳ್ತಾನೆ, ಹೇಗೆ ಈ ಡಿಸ್ಪ್ಯೂಟ್ಗಳನ್ನು ಕಮ್ಮಿ ಮಾಡಬೇಕು ಅಂತ ಒಂದು ಕ್ವಶನ್ ಕೇಳ್ತಾನೆ. ಹ್ಯಾಮ್ಲೆಟ್ ಕೇಳಿದಾಗ ಶೇಕ್ಸ್ಪಿಯರು ಅದರಲ್ಲಿ ಉತ್ತರ ಬರೋದು ಕಿಲ್ ಆಲ್ ಲಾಯರ್ಸ್ ಅಂತ. ಕಿಲ್ ಆಲ್ ಲಾಯರ್ಸ್, ದೇರ್ಫೋರ್ ದೇರ್ ವಿಲ್ ನಾಟ್ ಬಿ ಡಿಸ್ಪ್ಯೂಟ್ ಎಟ್ ಆಲ್ ಅಂತ. ಸಿ, ದಿಸ್ ಈಸ್ ನಾಟ್ ದಿ ವೇ. ಶೇಕ್ಸ್ಪಿಯರಿನ ಒಂದು ಇದು we cannot have, because lawyers are considered as social engineers. They are the people who have to act as the shock absorbers in society. And people, when they have got disharmony in a society, it is the lawyer who takes up the responsibility and tries to cool down the situation and also tries to have justice for the needy person is concerned. And ಹಿಂದೆ ಒಂದು ಕಾಲದಲ್ಲಿ ಅಂದರೆ ಪ್ರಾಬಲಿ ನಾವುಗಳು ಓದಿದ ಕಾಲದಲ್ಲಿ ಅಥವಾ ಆದ ನಂತರ ಒಂದು ಸ್ವಲ್ಪ ದಿವಸ ಒಂದು ರೀತಿಯ ನಾಣ್ಣುಡಿ ಅಂತಲೇ ಹೇಳ್ಬೋದು. ಥಿಂಕಿಂಗ್ ಏನಂದರೆ ಎಲ್ಲಿಯೂ ಸಲ್ಲದವನು ಇಲ್ಲಿ ಸಲ್ಲುತ್ತಾನೆ ಅಂತ ಹೇಳಿ ಲಾ ಕಾಲೇಜುಗಳಿಗೆ ಎಲ್ಲರೂ ಸೇರಿಬಿಡ್ತಿದ್ವಿ. ಆಮೇಲೆ ಬೆಳಗ್ಗೆ ಹೊತ್ತು 7 ಗಂಟೆಯಿಂದ 10 ಗಂಟೆನೋ ಏನೋ ಲಾ ಕಾಲೇಜು, ಆನಂತರ ನಮ್ಮ ವೃತ್ತಿ. ಲಾ ಕಾಲೇಜಸ್ ವರ್ ಮೆಂಟ್ ಮೋರ್ ಎಸ್ ಎ ಪಾರ್ಕಿಂಗ್ ಏರಿಯಾ ಫಾರ್ ದಿ ಪೀಪಲ್ ಹೂ ಹ್ಯಾಡ್ ದಿ ಕಾರ್ ಡ್ಯೂರಿಂಗ್ ದೋಸ್ ಡೇಸ್. ಆದರೆ ಇವತ್ತಿನ ಒಂದು ಲಾ ಕಾಲೇಜುಗಳು ಅಥವಾ ಲಾ ವಿದ್ಯಾಭ್ಯಾಸ ಹಾಗಲ್ಲ. ಇವಾಗ ಲಾ ವಿದ್ಯಾಭ್ಯಾಸ ಅಂದರೆ ಎಲ್ಲ ಇದ್ರ ಸಿಕ್ಕಿದ್ರೂ ನಮಗೆ ಲಾ ವಿದ್ಯಾಭ್ಯಾಸ ಬೇಕು. ದ ಲಾ ಇಸ್ ದಿ ಫಸ್ಟ್ ಪ್ರಯಾರಿಟಿ. ದಟ್ ಇಸ್ ದಿ ಥಿಂಗ್ ನೌ ದಿ ಮಾಡರ್ನ್ ಸೊಸೈಟಿ ಈಸ್ ಥಿಂಕಿಂಗ್. ನಾಟ್ ದಿ ಸೊಸೈಟಿ ವಾಟ್ ವಿ ವರ್ ಥಿಂಕಿಂಗ್ earlier. Our thinking is old thinking which has no value during these days. Therefore, when you have to think for the new generation, new evolution of India tomorrow, not India yesterday. If you have to think about India tomorrow, you have to get yourself equipped with the legal system and also the procedural laws are concerned. That is why I am mentioning all these aspects, and during this particular 2.5 hours, first thing I would like to take you in brief about the framework of Civil Procedure Code, and later on we will go to some of the topics which are relevant for the purpose of the future development is concerned. In the meanwhile, we also have a question and answer program, if possible, if it is permitted by the members of the bar. Then we'll have the literary interaction is concerned. Now, as I told you earlier, the Civil Procedure Code 1908 has got 2 parts. One part is the part which is enacted as by the Parliament. And before going to this aspect, we must know that in India we have got Constitution as the supreme law, and Civil Procedure Code is one of the law which is enacted by the Parliament. In the distribution of powers between the Parliament and state legislature, we have got 7th schedule. In 7th schedule, we have got 3 lists: union list, state list, and concurrent list. And in respect of the laws, or in respect of the entries which are enumerated in union list, 1 to 90 is concerned, the Parliament has got exclusive domain to make law. And in respect of the state list entries, it is the state legislature which has got the power to make law. And concurrent list is a list where both the Parliament and state can make law, and out of which the law made by the Parliament prevails over the state law unless the state law obtains the sanction of the President of India. This is the legal framework as to how the law is being enacted, the power or authority to enact. In fact, before continuing here, when I said about power, one thing strikes in my mind, that is about Oliver Cromwell. Oliver Cromwell, as many of the seniors know, was responsible to bring about the Long Parliament in England. If you read the legal and constitutional history of England, you get actually the period which is known as Long Parliament period. At that time, Oliver Cromwell was responsible. James III was the King of England, and the question was, the people were fed up with the rule of James III, and therefore the people rebelled against James III. And later on we had the revolution, and in that revolution James III was brought to the parliament. According to English system, the king is the head of the parliament also. And he said, who gave you the power to call me here? See, this is where actually is power aspect I am telling you. Because as a lawyer, ನಾವು ಏನು ಮಾಡಬೇಕು, ಮೊದಲು ಯೋಚನೆ ಅಂದರೆ, ನಿನಗೆ ಯಾರಪ್ಪ ಅಧಿಕಾರ ಕೊಟ್ಟರು, ನಿನಗೆ ಯಾವ ಅಧಿಕಾರದಿಂದ ಬಂತು ಈ ಕಾನೂನು ಅನ್ನೋದು. ಅದನ್ನು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋಕ್ಕೆ ನಾನು ಇದನ್ನು ಹೇಳ್ತಾ ಇರೋದು, ಆಲಿವರ್ ಕ್ರಾಮ್ವೆಲ್ ಇದನ್ನು. ಈ ಹೂ ಗೇವ್ ಯು ದಿ ಪವರ್ ಇಸ್ ದಿ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಥಿಂಗ್. ಲೈಕ್ವೈಸ್, ಹೂ ಗೇವ್ ದಿ ಪವರ್ ಟು to frame the civil procedure code ಅಂತ ಇದನ್ನು ತಗೊಂಡಾಗ ಪಾರ್ಲಿಮೆಂಟಿನ ನಮ್ಮ ಸಂವಿಧಾನದ ಬಗ್ಗೆ ನಾವು, ಯಾಕಂದರೆ ಯಾವುದೇ ಒಂದು ಕಾನೂನು ಸಂವಿಧಾನಬದ್ಧವಾಗಿರಬೇಕೇ ವಿನಃ ಸಂವಿಧಾನ ವಿರೋಧವಾಗಿರಬಾರ್ದು. ಸಂವಿಧಾನ ವಿರೋಧವಾಗಿದ್ದರೆ ಅಂತಹ ಒಂದು ಕಾನೂನು ಸಿಂಧುತ್ವವನ್ನು ಹೊಂದೋದಿಲ್ಲ. ಆದ್ದರಿಂದ ಮೊದಲನೇದಾಗಿ ಸಂವಿಧಾನದ ಒಂದು ಬಗ್ಗೆ ನಾವು ಪರಿಶೀಲನೆ ಮಾಡಿದ್ರೆ ಇದಕ್ಕೆ ಅಧಿಕಾರ ಇದೆಯಾ ಇಲ್ವಾ. ಯಾಕೆಂದ್ರೆ ನಾವು ಹಿಂದಿನ ಮಹಾರಾಜರ ಕಾಲಗಳಲ್ಲಿ ರಾಜ ಹೇಳಿದ್ದೆ ಕಾನೂನು ಆ ಥರ ಇತ್ತು. ಆಮೇಲೆ ಎಷ್ಟೋ ಬದಲಾವಣೆ ಆಗಿದೆ, ಅದು ಬೇರೆ, ನಾನು ಆಗಿಲ್ಲ ಅಂತೆಲ್ಲ ಹೇಳಿದ್ದು. ಆದರೆ ಇವಾಗಿನ ಒಂದು ನಮ್ಮ ಈ ವಿಚಾರದ ಯುಗದಲ್ಲಿ ಭಾರತದ ಸಂವಿಧಾನ ಇಸ್ ದಿ ಮೇನ್ ಲಾ ಫಾರ್ ದ ಕಂಟ್ರಿ. ಆ್ಯಂಡ್ ಯಾವುದೇ ಒಂದು ನಾವು ಕಾನೂನನ್ನು ರಚನೆ ಮಾಡಿದ್ರೆ ಅಥವಾ ಯಾವುದೇ ಒಂದು ಕ್ರಿಯೆಯನ್ನು ಮಾಡಿದ್ರೆ ಅದು ಸಂವಿಧಾನಬದ್ಧವಾಗಿರಬೇಕೇ ವಿನಃ ಸಂವಿಧಾನಕ್ಕೆ ವಿರೋಧವಾಗಿ ಇರೋ ಹಾಗೆ ಇಲ್ಲ. ಈ ಒಂದು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಇದನ್ನು ರಚನೆ ಮಾಡೋದಕ್ಕೆ ಭಾರತದ ಸಂವಿಧಾನದಲ್ಲಿ 7th ಶೆಡ್ಯೂಲ್ ಅದರಲ್ಲಿ 3rd ಲಿಸ್ಟ್ನಲ್ಲಿ, ಕನ್ಕರೆಂಟ್ ಲಿಸ್ಟ್ನಲ್ಲಿ ಕೊಟ್ಟಿರುವಂತಹ ಅಧಿಕಾರದ ವ್ಯಾಪ್ತಿಯಿಂದ ಪಾರ್ಲಿಮೆಂಟ್ನವರು ಈ ಒಂದು ತಿದ್ದುಪಡಿಯನ್ನು ಮಾಡಿದ್ದಾರೆ. ಈ ಒಂದು ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ 1908 ಅನ್ನೋದನ್ನು ನಾವು ಪರಿಗಣನೆಗೆ ತಗೊಂಡಾಗ ಆವಾಗಿನ ಪಾರ್ಲಿಮೆಂಟ್ ಅಫ್ಕೋರ್ಸ್ ಮಾಡಿದ್ರು. ಆದರೆ ಆವಾಗಿನ ಪಾರ್ಲಿಮೆಂಟ್ ಮಾಡುವಾಗ ರೂಲ್ಸ್ ಆಫ್ ಇಂಗ್ಲೆಂಡ್ ಆ್ಯಂಡ್ ಆಲ್ಸೋ ರೂಲ್ಸ್ ಆಫ್ ನ್ಯೂಯಾರ್ಕ್ ವಾಸ್ ಟೇಕನ್ ಇನ್ ಟು ಕನ್ಸಿಡ್ರೇಷನ್. ಆವಾಗ ಅದನ್ನು ತಗೊಂಡು ಒಂದು ಕಾನೂನು ಮಾಡಿದರು. ಈ ಒಂದು ಕಾನೂನಿನಲ್ಲಿ ನಾನು ಆಗಲೇ ಹೇಳಿದಾಗೆ 2 ಭಾಗಗಳಿದೆ. ಒಂದು ಆ್ಯಕ್ಚುಲಿ ಸೆಕ್ಷನ್ 1ರಿಂದ 158ವರೆಗೂ, ಇನ್ನೊಂದು ಭಾಗ ಆ್ಯಕ್ಚುಲಿ ರಿಲೇಟಿಂಗ್ ಟು ಆರ್ಡರ್ಸ್. ಆ್ಯಂಡ್ ಈ 2 ಭಾಗ, ಇದಕ್ಕೆ ಪೂರ್ವದಲ್ಲಿ ಇದ್ದಂತಹ ಒಂದು ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ನಲ್ಲಿ 8 ಭಾಗಗಳಿತ್ತು, 4 ಭಾಗಗಳಿತ್ತು ಈ ಶೆಡ್ಯೂಲ್ಗಳು. ಆಮೇಲೆ 300 ಚಿಲ್ಲರೆ ಸೆಕ್ಷನ್ಗಳಿತ್ತು. ಅದನ್ನೆಲ್ಲ ಇದು ಮಾಡಿ ಈಗ ಮಾಡಿದ್ದಾರೆ. ಈಗ ಸೆಕ್ಷನ್ 1ರಿಂದ 158 ಅಮೆಂಡ್ ಮಾಡೋದಕ್ಕೆ ಅಧಿಕಾರ ಇರೋದು ಪಾರ್ಲಿಮೆಂಟಿಗೆ. ಆದರೆ ನಮ್ಮ ದೇಶದಲ್ಲಿ ನಾವು ವೈವಿಧ್ಯಮಯವಾದಂತಹ ದೇಶ, ಆ್ಯಂಡ್ ಯೂನಿಟಿ ಇನ್ ಡೈವರ್ಸಿಟಿ. ಅಂಥ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ಪಂಜಾಬ್ನಲ್ಲಿ ಇರುವಂಥ ಪದ್ಧತಿಗಳು ಕರ್ನಾಟಕದಲ್ಲಿ ಇಲ್ಲದೇ ಇರ್ಬೋದು, ಕರ್ನಾಟಕದಲ್ಲಿ ಇರುವಂಥ ಪದ್ಧತಿಗಳು ಬಂಗಾಳದಲ್ಲಿ ಇಲ್ಲದೇ ಇರ್ಬೋದು. ಅಂಥ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ಅಲ್ಲಿನ ಒಂದು ವ್ಯವಸ್ಥೆಗೆ ತಕ್ಕಂತೆ ಇರೋದಕ್ಕೆ ಅಲ್ಲಿನ ಹೈಕೋರ್ಟ್ಗಳಿಗೆ ಕೆಲವು ರೂಲ್ಸ್ಗಳನ್ನ ಮಾಡೋದಕ್ಕೆ ಅಧಿಕಾರ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದೇ ರೀತಿ ಸ್ಟೇಟ್ ಲೆಜಿಸ್ಲೇಚರ್ಗೂ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ನಾವು ಈ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡನ್ನು ನೋಡಬೇಕು. ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಹೆಸರು ಹೇಳುವಾಗೇ ಇದು ಪ್ರೊಸೀಜರ್ ಅಲ್ಲ. ಆ್ಯಂಡ್ ಪ್ರೊಸೀಜರ್ ಅಲ್ಲ ಅಂದರೆ ಇದೇನು ರೆವಿನ್ಯೂ ಕೋರ್ಟ್ಗೆ ಅಪ್ಲೈ ಆಗುತ್ತಾ, ಅಥವಾ ಇದು ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ಗೆ ಅಪ್ಲೈ ಆಗುತ್ತಾ, ಅಥವಾ ಟ್ಯಾಕ್ಸ್ ಕೋರ್ಟ್ಗಳಿಗೆ ಅಪ್ಲೈ ಆಗುತ್ತಾ ಅಂತ ಪ್ರಶ್ನೆಗಳು ಬರ್ತವೆ. ಯಾಕಂದರೆ ಕೋರ್ಟ್ ಅಂದ ತಕ್ಷಣ ನಾನಾ ರೀತಿಯಾದಂಥ ಕೋರ್ಟ್ಗಳು ನಾವು ಇತ್ತೀಚಿನ ಒಂದು ಇದರಲ್ಲಿ ನೋಡ್ತೀವಿ. ಆದರೆ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋರ್ಟ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಅಪ್ಲೈ ಆಗೋಲ್ಲ. ಇದು ಮೊದಲನೇ ವಿಷಯ. ಆ್ಯಸ್ ಜೂನಿಯರ್ಸ್, ಯಾಕಂದ್ರೆ ಸಿ ಪಿ ಸಿ ಅಪ್ಲೈ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮುಂದೆ ಹೋಗಿ ನೀವು ಸಿ ಪಿ ಸಿ ಅಪ್ಲೈ ಮಾಡ್ತೀನಿ ಅಂದರೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ವಿಲ್ ನಾಟ್ ಎಂಟರ್ಟೈನ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ಇನ್ ಸಿ ಪಿ ಸಿ. ಸೊ ಸಿ ಪಿ ಸಿ ಅಪ್ಲೈಸ್ ಓನ್ಲಿ ಇನ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ಸ್, not in magistrate court. Second thing is, CPC is not applicable in revenue courts, and to limited extent CPC is applicable in tax matters. And ನಮಗೆ ಫ್ರೆಂಡು ಇಲ್ಲಿ ಇರೋ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮ್ನವರು, ಅವರ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮ್ನಲ್ಲಿ ನೀವು ಸಿ ಪಿ ಸಿನ ಅಪ್ಲೈ ಮಾಡ್ತೀನಿ ಅಂದರೆ ಆಗೋದಿಲ್ಲ. ಓನ್ಲಿ ಲಿಮಿಟೆಡ್ ಎಕ್ಸ್ಟೆಂಟಿಗೆ ಎಷ್ಟು ಇದೆಯೋ ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ ಸಿ ಪಿ ಸಿನ ಅಪ್ಲೈ ಮಾಡ್ಬೋದು. ಎಲ್ಲ ಸಿ ಪಿ ಸಿನಲ್ಲಿ ಇರೋ ಎಲ್ಲ ಭಾಗಗಳನ್ನೂ ನಾವು ಅಪ್ಲೈ ಮಾಡೋದಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಆದ್ದರಿಂದ ಫಾರ್ ಮೈ ಯಂಗ್ ಕಲೀಗ್ಸ್ ಐ ಟೆಲ್ ಯು ದ್ಯಾಟ್ ಸಿ ಪಿ ಸಿ ಈಸ್ ನಾಟ್ ಎಕ್ಸಾಸ್ಟಿವ್. ಪ್ಲೀಸ್ ನೋಟ್ ವೆದರ್ ಸಿ ಪಿ ಸಿ ಈಸ್ ಎಕ್ಸಾಸ್ಟಿವ್. ನೋ, ಸಿ ಪಿ ಸಿ ಈಸ್ ನಾಟ್ ಎಕ್ಸಾಸ್ಟಿವ್. ದಟ್ ಇಸ್ ಒನ್ ಫಸ್ಟ್ ಪಾಯಿಂಟ್ ಯು ಮಸ್ಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಆ್ಯಂಡ್ ಫಸ್ಟ್ ಐ ಟೋಲ್ಡ್ ಯು ಸ್ಟ್ರಕ್ಚರ್ ಆಫ್ ಸಿ ಪಿ ಸಿ. ಸ್ಟ್ರಕ್ಚರ್ ಆಫ್ ಸಿ ಪಿ ಸಿನಲ್ಲಿ ನಮಗೆ ಭಾಗಗಳನ್ನು ಮಾಡಿದ್ದಾರೆ, ಸೆಕ್ಷನ್ಗಳಿದೆ. ಆ ಸೆಕ್ಷನ್ಗಳು ನಲ್ಲಿ ಮೊದಲನೇ ಕೆಲವು ಸೆಕ್ಷನ್ಗಳಲ್ಲಿ ಈ ಸಿ ಪಿ ಸಿ ಅಪ್ಲಿಕಬಿಲಿಟಿ ಬಗ್ಗೆ ಬರುತ್ತೆ. 2019 ತನಕ ಸಿ ಪಿ ಸಿ ವಾಸ್ ನಾಟ್ ಅಪ್ಲಿಕಬಲ್ ಟು ಜಮ್ಮು ಆ್ಯಂಡ್ ಕಾಶ್ಮೀರ್ ಅಂತ ಇತ್ತು. 2019ರಲ್ಲಿ ಆದಂತಹ ಒಂದು ಪರಿವರ್ತನೆಯಿಂದ ಇವಾಗ ಭಾರತದಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಕಾನೂನನ್ನು ಇದು ರಚನೆ ಆಗುತ್ತೋ ಪಾರ್ಲಿಮೆಂಟಿಂದ, ಅದು ಜಮ್ಮು ಆ್ಯಂಡ್ ಕಾಶ್ಮೀರ್ಗೂ ಅಪ್ಲೈ ಆಗುತ್ತೆ. ಆದರೆ ಸಿ ಪಿ ಸಿ ಈಸ್ ನಾಟ್ ಅಪ್ಲಿಕಬಲ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪೀಪಲ್ ಆಫ್ ಟ್ರೈಬಲ್ ಏರಿಯಾ. See, this is a thing which you have to remember, youngsters. Especially I'm stressing, because now the world is wide. The youngster of Bagalkot may become a judicial officer in Assam or in some area of Meghalaya, or some of those areas are concerned. Earlier we had actually ಜುಡಿಷಿಯಲ್ ಸರ್ವಿಸ್ ಅಂದರೆ ಎಲ್ಲೋ ಒಂದು ಆ ಒಂದು ಸ್ಟೇಟ್ನಲ್ಲಿ ಮಾತ್ರ ಇತ್ತು ಅನ್ನೋ ಒಂದು ಇದಿತ್ತು. ಆದರೆ ಇವತ್ತಿನ ಒಂದು ಕಾಂಪಿಟೇಷನ್ನಲ್ಲಿ ಹಾಗಲ್ಲ. ಆ್ಯಂಡ್ ಯು ಮೇ ಇವನ್ ಟೇಕ್ ಅಪ್ ದಿ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಆಫ್ ಪ್ರಿಪೇರಿಂಗ್ ಎ ಫ್ಲೋ ಚಾರ್ಟ್ ರಿಲೇಟಿಂಗ್ ಟು ಡಿಜಿಟಲೈಸೇಷನ್ ಆಫ್ ದಿ ಸಿ ಪಿ ಸಿ ಇಸ್ ಕನ್ಸರ್ನ್. ಸೊ ಸಿ ಪಿ ಸಿ ಟ್ರೈಬಲ್ ಏರಿಯಾದಲ್ಲಿ ಇರುವಂತಹ ಅವ್ರುಗಳಿಗೆ ಅಪ್ಲೈ ಆಗೋಲ್ಲ. ಕರ್ನಾಟಕದಲ್ಲಿ ಅಫ್ಕೋರ್ಸ್ ಅಂಥ ಒಂದು ಟ್ರೈಬಲ್ ಏರಿಯಾ ಯಾವುದೂ ಇಲ್ಲ ಇಲ್ಲಿ. ಆದರೆ ಕೆಲವು ಟ್ರೈಬಲ್ ಏರಿಯಾಗಳು ಇವತ್ತಿಗೂ ಅವರುಗಳಿಗೆ ವ್ಯಾಜ್ಯಗಳಿದ್ದರೆ ಸಿ ಪಿ ಸಿ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ. ಅವರ ವ್ಯಾಜ್ಯಗಳನ್ನ ಟ್ರೈಬಲ್ ಕೋರ್ಟ್ಗಳೇ ಇರುತ್ತೆ. ಆ ಟ್ರೈಬಲ್ ಕೋರ್ಟ್ನವರೇ ಇತ್ಯರ್ಥ ಮಾಡ್ಕೊಳ್ತಾರೆ. ಅದಕ್ಕೆ ಸಿ ಪಿ ಸಿ ಗಿ ಪಿ ಸಿ ಏನೂ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ. ಆದ ಕಾರಣ ಸಿ ಪಿ ಸಿ ವೆದರ್ ಇಟ್ ಈಸ್ ಅಪ್ಲಿಕಬಲ್ ವಿತ್ ಎಕ್ಸಾಸ್ಟಿವ್ನೆಸ್, ನೋ. ಅದಕ್ಕೆ ಆ ಒಂದು ವಿಷಯದಲ್ಲಿ ನಾನು ನಿಮಗೆ ಹೇಳ್ತಿರೋದು, ಸಿ ಪಿ ಸಿ ಈಸ್ ನಾಟ್ ಎಕ್ಸಾಸ್ಟಿವ್. ಸಿ ಪಿ ಸಿನಲ್ಲಿ ನಮಗೆ ದೊಡ್ಡ ಅಸ್ತ್ರ ಅಂದರೆ 151 ಸೆಕ್ಷನ್ 151. ಯಾತಕ್ಕೆ ಇದನ್ನು 151 ಕೊಟ್ಟರು? ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡಲ್ಲಿ ಕೊಟ್ಟಿಲ್ವಲ್ಲ. ಅಂತ ಸೆಕ್ಷನ್ ಇನ್ಹರೆಂಟ್ ಪವರ್ ಆಫ್ ದಿ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ಸ್ ಬಂದಾಗ ನಮಗೆ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಅಥವಾ ಇವಾಗ ಹೊಸ ಒಂದು ಸಂಹಿತೆ ಬಂದಿದೆಯಲ್ಲ, ಅದರಲ್ಲೂ ಇನ್ಹರೆಂಟ್ ಪವರ್ ಇಸ್ ಓನ್ಲಿ ಫಾರ್ ದಿ ಹೈಕೋರ್ಟ್. ಆದರೆ CPC ಒಳಗೆ ಇನ್ಹರೆಂಟ್ ಪವರ್ ಫಾರ್ ಆಲ್ ಕೋರ್ಟ್ಸ್, ಇವನ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಜೂನಿಯರ್ ಡಿವಿಷನ್ ಆಲ್ಸೋ ಹ್ಯಾಸ್ ಗಾಟ್ ಇನ್ಹರೆಂಟ್ ಪವರ್. ಯಾಕೆ ಅಂದರೆ ಈ ಇನ್ಹರೆಂಟ್ ಪವರು ನ್ಯಾಯವನ್ನು ಇತ್ಯರ್ಥ ಮಾಡುವಾಗ ಯಾವ ರೀತಿ ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ನಾವು ಇತ್ಯರ್ಥ ಮಾಡಬೇಕು ಅನ್ನೋದು ಬರುತ್ತೆ. ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡಲ್ಲಿ ಆ ಥರ ಸಂದರ್ಭಗಳು ಬರೋದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸಿವಿಲ್ ಕೋರ್ಟ್ಗಳಿಗೆ ಇನ್ಹರೆಂಟ್ ಪವರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ಕಾನೂನಿನಲ್ಲಿ ಇಲ್ಲದೇ ಇರುವಂತಹ ವಿಷಯಗಳು ಏನೇ ಇದ್ದರೂ ಅಂತಹ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಇನ್ಹರೆಂಟ್ ಪವರ್ ಇದೆ. ಇನ್ ಆರ್ಡರ್ ಟು ವರ್ಕೌಟ್ ದಿ ಜಸ್ಟಿಸ್, ಇನ್ ಆರ್ಡರ್ ಟು ವರ್ಕೌಟ್ ದಿ, ಬಿಕಾಸ್ ಕ್ರಿಮಿನಲ್ ಸೈಡ್ನಲ್ಲಿ ಮುಖ್ಯವಾದಂತಹ ವಿಷಯ ನೀವು ಗಮನಕ್ಕೆ ತಗೋಬೇಕಾದ್ರೆ, ಪ್ರತಿಯೊಬ್ಬ ಆರೋಪಿಯು ನ್ಯಾಯಾಲಯ ಅವನು ತಪ್ಪಿತಸ್ಥ ಅಂತ ಹೇಳೋವರೆಗೂ ಅವನು ತಪ್ಪಿತಸ್ಥ ಅಲ್ಲ, ಬರೀ ಆರೋಪಿ ಆಗಿರ್ತಾನೆ. ನ್ಯಾಯಾಲಯ ಅವನು ತಪ್ಪು ಮಾಡಿದ್ದಾನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮಾತ್ರ ಅವನು ತಪ್ಪಿತಸ್ಥ. ಆದ್ದರಿಂದ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ನಲ್ಲಿ ಬರ್ಡನ್ ಆಫ್ ಪ್ರೂಫ್ ಈಸ್ ಹೆವಿ ಆನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್. ಬಟ್ ವೆರಾಸ್ ಇನ್ ಸಿವಿಲ್ ಸೈಡ್ ವಿ ಡೋಂಟ್ ಹ್ಯಾವ್ ದಟ್ ಸಿಸ್ಟಮ್. ಸಿವಿಲ್ ಸೈಡಲ್ಲಿ ವಿ ಹ್ಯಾವ್ ಗಾಟ್ ಎ ಸಿಸ್ಟಮ್ ನೋನ್ ಆ್ಯಸ್ ಅಡ್ವರ್ಸೋರಿಯಲ್ ಸಿಸ್ಟಮ್. ಅಡ್ವರ್ಸೋರಿಯಲ್ ಸಿಸ್ಟಮ್ ಒಂದು. ಎರಡನೇದು, ವಿ ಹ್ಯಾವ್ ಗಾಟ್ ಟು ರಿಮೆಂಬರ್ the system which we are having in civil law is preponderance of probabilities. Whereas in criminal side you don't have preponderance of probabilities. What you have is proof beyond reasonable doubt in criminal side. But whereas in civil side it is not the proof beyond reasonable doubt, it is the preponderance of probability is concerned. Who is near to the truth? Whose case is near to the truth is the preponderance of probability. ಈ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ಯಾರು ವಾದ ಮಾಡಿರೋ ವಿಷಯ ಸತ್ಯಕ್ಕೆ ಹತ್ತಿರ ಹೋಗುತ್ತೆ ಅಂತ. ಆದರೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ಗಳಲ್ಲಿ ಪೂರ್ಣ ಪ್ರೂವ್ ಆಗಬೇಕು. ಅದರಿಂದ ಒಂದು ಅಂಶ ಅಕಸ್ಮಾತ್ ಸಂದೇಹ ಇದ್ದರೆ ಆ ಸಂದೇಹ ಆರೋಪಿಯ ಕಡೆಗೆ ವಾಲುತ್ತೆ. ಆದರೆ ಸಿವಿಲ್ ಕೇಸ್ನಲ್ಲಿ ಹಾಗಲ್ಲ. ಆದ್ದರಿಂದ ಪ್ರಿಪಾಂಡರೆನ್ಸ್ ಆಫ್ ಪ್ರಾಬಬಿಲಿಟಿಯಲ್ಲಿ ಯಾರು ಹತ್ತಿರ ಹೋಗ್ತಾರೆ ಸತ್ಯಕ್ಕೆ ಅನ್ನೋದು ಮುಖ್ಯ. ಈ ಪ್ರಿಪಾಂಡರೆನ್ಸ್ ಆಫ್ ಪ್ರಾಬಬಿಲಿಟೀಸ್ ಬಂದಾಗ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬಹಳಷ್ಟು ಜವಾಬ್ದಾರಿ ಇರುತ್ತೆ. ಸತ್ಯವನ್ನು ಮುಚ್ಚಿಡೋದಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಿದಾಗ ಆ ಸತ್ಯವನ್ನು ಹೊರಗೆ ಹಾಕೋದಕ್ಕೆ ಬೇರೆ ವಿರೋಧ ಪಾರ್ಟಿಯವರು ಸಹ ಇದು ಮಾಡೋದು. ಅದಕ್ಕೆ ಅಡ್ವರ್ಸೋರಿಯಲ್ ಸಿಸ್ಟಮ್ ಅಂತ ನಾವು ಹೇಳ್ತೀವಿ. ಅಡ್ವರ್ಸೋರಿಯಲ್ ಸಿಸ್ಟಮಲ್ಲಿ ಯಾರು ಒಂದು ಇದನ್ನು ಪ್ರತಿಪಾದನೆ ಮಾಡ್ತಾರೋ ಅವರು ಅದನ್ನು ರುಜುವಾತು ಮಾಡಬೇಕು. ಸೆಕ್ಷನ್ 100, 101, 102 ಆಫ್ ದಿ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್ 1872, if you look at, it speaks much about burden of proof. One who propounds, he has to prove. ಆದ್ದರಿಂದ ಈ ಒಂದು ಸನ್ನಿವೇಶದಲ್ಲಿ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸೆಕ್ಷನ್ 151 ಪ್ರಕಾರ ಇನ್ಹರೆಂಟ್ ಪವರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವನ್ ಎ ಸಿವಿಲ್ ಜಡ್ಜ್ ಆಫ್ ಎ ಜೂನಿಯರ್ ಡಿವಿಷನ್ ಹ್ಯಾಸ್ ಗಾಟ್ ವಾಸ್ಟ್ ಪವರ್ ಅಬೌಟ್ ಇನ್ಹರೆಂಟ್ ಪವರ್ ಇಸ್ ಕನ್ಸರ್ಟ್. ವೆರಾಸ್ ಇನ್ ಕ್ರಿಮಿನಲ್ ಸೈಡ್ ಯು ಡೋಂಟ್ ಹ್ಯಾವ್ inherent power for a civil judge, junior division, or even for a district judge. It is only for the high court they have got the power is concerned. Therefore, in this background, if you look at the CPC, for all situations, you can't work out remedy in CPC. Therefore, CPC is not exhaustive, and we have to work out the remedy depending upon the situation and also the human behavior is concerned, and therefore provisions have been made. And now we have actually made certain provisions relating to scientific investigation in CPC. Earlier it was not there. Order 26, Rule 10, commission appoint ಮಾಡೋದು ಅಂತ ಇತ್ತು. ಆದರೆ ಕಮಿಷನ್ ಅಪಾಯಿಂಟ್ ಮಾಡುವಾಗ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟನ್ನು ಕಮಿಷನ್ ಮಾಡ್ತೀವಿ. ಅದಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಎಲ್ಲಿತ್ತು? CPCನಲ್ಲಿ 151 ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ವಿ, ರೆಡ್ ವಿತ್ ಆರ್ಡರ್ 26 ರೂಲ್ 1 ಅಂತ ಇದು ಮಾಡಿದ್ವಿ. ಆದರೆ ಇವಾಗ ಸಿ ಪಿ ಸಿನಲ್ಲಿ ಅಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಇಫ್ ದಿ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಗಾಟ್ ಎ ಡೌಟ್ ಅಬೌಟ್ ದಿ ಸೈಂಟಿಫಿಕ್ ಆಸ್ಪೆಕ್ಟ್, then under Order 26 Rule 10A of the Civil Procedure Code, a scientist or an expert could be appointed. ಇದರಿಂದ ಎಷ್ಟೋ ಕೇಸುಗಳಲ್ಲಿ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡೋದಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ, 26 Rule 10 ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಅನ್ನೋ ಒಂದು ವಾದವನ್ನು ಅನೇಕರು ಮಂಡಿಸ್ತಾ ಇದ್ದರು. ಆವಾಗ ನ್ಯಾಯಾಲಯದವರು ಇಲ್ಲ ಆ್ಯಕ್ಚುಲಿ ಸೆಕ್ಷನ್ 151ನಲ್ಲಿ ಪವರ್ ಇದೆ ಅಂತ ಇದು ಮಾಡೋರು. ಈ ಒಂದು ರೀತಿಯ ದ್ವಂದ್ವದಲ್ಲಿ ಇದ್ದಾಗ ಇಲ್ಲ, ಈ ದ್ವಂದ್ವ ಇರಬಾರ್ದು ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ 26 Rule 10A ಅನ್ನೋ ಒಂದು ಪ್ರಾವಿಷನನ್ನು ಮಾಡಿದ್ದಾರೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಒನ್ ಆಫ್ ದಿ ರೀಸೆಂಟ್ ಕೇಸ್ನಲ್ಲಿ ಏನಾಯಿತು, ದಿ ಪ್ಲೇಂಟಿಫ್ ಅವನ ಎವಿಡೆನ್ಸ್ ಮುಗಿಸ್ದ, ಡಿಫೆಂಡೆಂಟ್ ಅವನ ಎವಿಡೆನ್ಸ್ ಮುಗಿಸ್ದ. ಆ ಕೇಸ್ನಲ್ಲಿ ಏನಂದರೆ, ಈ ಒಂದು ಮಗು ಈ ಪ್ಲೇಂಟಿಫಿಗೆ ಡಿಫೆಂಡೆಂಟ್ಗೆ ಹುಟ್ಟಿದ್ದೋ ಅಲ್ವೋ ಅನ್ನೋದು ಒಂದು ವಿಷಯ ಆಗಿದೆ. ಈ ವಿಷಯದಲ್ಲಿ ವಿವಾದ ಬಂದಾಗ ಅವರುಗಳು ತಮ್ಮ ವಿವಾದ ಬಗ್ಗೆ ನಡೆಸಿದಾಗ DNA ಟೆಸ್ಟ್ಗೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ಅಫ್ಕೋರ್ಸ್ ದಿ Supreme Court has said that Section 112 of the Evidence Act 1872 is there, therefore ನಾರ್ಮಲ್ ಆಗಿ DNA ಟೆಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ಸನ್ನು ಹಾಕಬೇಡಿ ಅನ್ಲೆಸ್ ದರ್ ಇದೆ ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅಂತ. ಈ ಕೇಸ್ನಲ್ಲಿ ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ. ಯಾರು ಈ ಮಗುವಿನ ತಂದೆ DNA ಪ್ರಕಾರ ಅನ್ನೋದನ್ನು ಕಂಡುಹಿಡಿಯಬೇಕಾಗಿ ವಿವಾದ ಎಲ್ಲ ಆದ ನಂತರ ಇನ್ನೇನು ಜಡ್ಜ್ಮೆಂಟಿಗೆ ಕೊನೆಯ ವಾದದ ಸ್ಟೇಜಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ಸ್ವಾಮಿ, ನಾವೆಲ್ಲ ವಾದ ಇಬ್ಬರು ಮುಗಿಸಿದ್ದೀವಿ, ಇವಾಗ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾಯಿದ್ದೀವಿ, ಈ ಅಪ್ಲಿಕೇಶನ್ ಪ್ರಕಾರ ತಾವು ತೀರ್ಮಾನ DNA ಟೆಸ್ಟ್ ಬಂದುಬಿಟ್ರೆ ಕೇಸೇ ಮುಗಿದೋಗ್ಬಿಡುತ್ತೆ. ಸರಿ, ತಗೊಳ್ಳೋದೋ ಬೇಡವೋ ಅಂತ ಒಂದು ಜಿಜ್ಞಾಸೆ ಬಂತು. ಈ ಜಿಜ್ಞಾಸೆ ಬಂದಾಗ ಕೋರ್ಟ್ನವರು, ಏನು ರೀ ಆರ್ಡರ್ 26 ಯಾವಾಗ ಹಾಕೋದ್ರಿ ನೀವು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಇರುವಾಗ ಹಾಕೋದಾ, ಆ ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಜಲ್ಲಿ ಹಾಕೋದಾ, ಆಗೋದಿಲ್ಲ ಅಂತ ಮಾಡೋದು. ಆನಂತರ ಅದನ್ನು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರು, ವಜಾ ಮಾಡಿದ ಮೇಲೆ ಹೈಕೋರ್ಟ್ಗೆ ಹೋಯಿತು. ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಇಲ್ಲ ಇದು ಕರೆಕ್ಟಾಗಿ ಸ್ಟೇಜಲ್ಲೇ ಹಾಕಿದ್ದಾರೆ, ಯಾಕೆಂದರೆ ವಿವಾದಗಳೆಲ್ಲ ಆಗಿದೆ, ಇನ್ನು DNA ಟೆಸ್ಟಲ್ಲಿ ಫ್ಯಾಕ್ಚುಯಲ್ ಆಸ್ಪೆಕ್ಟ್ ಏನಿಲ್ಲ, ಸೈಂಟಿಫಿಕ್ ಎಕ್ಸಾಮಿನೇಷನ್ನು, ದೇರ್ ಫೋರ್ ದಟ್ ಈಸ್ ಪರ್ಮಿಸಿಬಲ್ ಅಂತ ಇದು ಮಾಡೋದು. ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ, ನಮ್ಮ ಒಂದು ಭಾವನೆ ಏನಿರುತ್ತವೆ, ಆರ್ಡರ್ 26 ಯಾವಾಗ ಹಾಕಬೇಕು, ಕೆಲವರು ಹೇಳ್ತಾರೆ ಆರ್ಡರ್ 26 ಅಪ್ಲಿಕೇಶನನ್ನು ಎವಿಡೆನ್ಸ್ ಕಲೆಕ್ಷನ್ ಆಗೋಕ್ಕೆ ಮುಂಚೆ ಹಾಕೋಂಗಿಲ್ಲ, ಇದು ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಬರಬೇಕು ಆನಂತರನೇ ಹಾಕಬೇಕು, ಅಪ್ರಿಸಿಯೇಷನ್ ಆಫ್ ದಿ ಎವಿಡೆನ್ಸ್ ಅಂತ. ಕೆಲವು ಜಡ್ಜ್ಮೆಂಟ್ಗಳು ಇಲ್ಲ ಈ ಆರ್ಡರ್ 26 ಅಪ್ಲಿಕೇಶನನ್ನು ಮೊದಲೇ ಹಾಕ್ಬೋದು ಅಂತ. ಮೊದಲೇ ಹಾಕ್ಬೋದು, ಕೊನೆಯಲ್ಲಿ ಹಾಕಬೇಕು, ಯಾವ ಸ್ಟೇಜಲ್ಲಿ ಟು ಫಿಶ್ ಔಟ್ ದಿ ಎವಿಡೆನ್ಸ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಪರ್ಮಿಟೆಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಟು ಫಿಶ್ ಔಟ್ ದಿ ಎವಿಡೆನ್ಸ್ ಆರ್ಡರ್ 26 ರೂಲ್, ಆರ್ಡರ್ 26 cannot be invoked. It could be invoked only for the purpose of establishing the evidence and not to fish out the evidence. The person who comes to the court has to prove his case or her case ಅಂತ ವಾದ ಮಾಡಿದ್ದು ಮಾಡಿದೆ. ಆದರೆ ಈ ಒಂದು ವಾದ ಸರಿನಾ ಅಲ್ವಾ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ, ಯಾಕಂದ್ರೆ ನಾನು ಹೇಳಿದ್ದೆ ನಿಮ್ಮ ಕೇಸ್ನಲ್ಲಿ ಅವನು ಕೊನೆಯ ಸ್ಟೇಜ್ ಇನ್ನೇನು ಆರ್ಗ್ಯುಮೆಂಟಿಗೆ ಬಂದಿರೋವಾಗ ಒಂದು 26 Rule 10A ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ. ಇದರಲ್ಲಿ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಇರುವಂತಹ ಇದನ್ನು DNA ಟೆಸ್ಟ್ ಕಳಿಸ್ಕೊಡಿ ಅಂತ. ಈ DNA ಟೆಸ್ಟ್ ಬಂದುಬಿಟ್ರೆ ಅವಾಗೆಲ್ಲ ಮುಗಿದೋಗ್ಬಿಡುತ್ತೆ, ಈ ಮಿಕ್ಕಿದೆಲ್ಲ ಇರೋದು ಮುಗಿದೋಗುತ್ತೆ ಅನ್ನೋ ಒಂದು ಈ ರೀತಿ ಸೈಂಟಿಫಿಕ್ ಡೆವಲಪ್ಮೆಂಟ್ಸು ಯಾವ್ಯಾವ ಥರ ಆಗುತ್ತೆ ಅನ್ನೋದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಯು ಕೆನಾಟ್ ಆ್ಯಕ್ಚುಲಿ think only about the old procedures which were prevailing about 50 years or 100 years back. And as youngsters, you have to take into account how the technology has changed, how the law has to change along with the changing technology. ಹಿಂದೆ ಒಂದು ಸಮಯದಲ್ಲಿ, ಅಂದರೆ 2000ಕ್ಕೆ ಹಿಂದೆ, ನಾನು ನಮಗಿಂತ ಹಿಂದೆ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ, ಸುಮಾರು 2000ಕ್ಕಿಂತ ಹಿಂದೆ ಎಷ್ಟೋ ಜನಕ್ಕೆ ಡಿಜಿಟಲ್ ಸಿಗ್ನೇಚರ್ ಅಂದರೆ ಏನೂ ಗೊತ್ತಿರಲಿಲ್ಲ. ಡಿಜಿಟಲ್ ಸಿಗ್ನೇಚರ್ ಹೆಸರೇ ಕೇಳಿರಲಿಲ್ಲ ಎಷ್ಟೋ ಜನ. ಆದರೆ ಇವತ್ತಿನ ಒಂದು ಕಾಲದಲ್ಲಿ ಅಥವಾ ಇವತ್ತಿನ ಒಂದು ಸಮಯದಲ್ಲಿ ಡಿಜಿಟಲ್ ಸಿಗ್ನೇಚರ್ ಅಂದರೆ ಏನು ಅಂತ ಯಂಗ್ಸ್ಟರ್ಸು ದೇ ಕ್ಯಾನ್ ಟೀಚ್ ಮೀ ಬೆಟರ್ ದ್ಯಾನ್ ವಾಟ್ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಟೆಲ್ ದೆಮ್. ಅಷ್ಟು ಇದಿದೆ. ಈಗ ಒಂದು ಹಿಂದಿನ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂದರೆ ಒಂದು ಕರಾರು ಬರೆದ್ರೆ ಅವನು ಕರಾರು ಬರೋದ, ಅವ್ನು ನನ್ನ ಮುಂದೆ ಸೈನ್ ಮಾಡ್ದ, ಇವಂದೇನೆ ಅಂತ ಎಲ್ಲ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟು ಆಮೇಲೆ ಡಿಸ್ಪ್ಯೂಟ್ ಬಂದರೆ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ಕಳಿಸಿ ಇಷ್ಟೆಲ್ಲ ಮಾಡ್ತಾಯಿದ್ವಿ. ಇವತ್ತಿನ ಈ ಟೆಕ್ನಾಲಜಿ ಯುಗದಲ್ಲಿ you have got to remember that the contracts are entered into between the government and the public, and government and public by using the digital signatures. When the digital signatures are used, how you have to prove the digital signature? What is a digital signature? What is an electronic signature? All these things have developed only after the Information Technology Act 2000 came into. That's why it said 2000. Earlier to 2000, many of us were not knowing anything about digital signature or electronic signature. But today, the situation is not like that. The entire scenario have changed. The digital signature or electronic signature could be affixed for many documents except will is consent. See, therefore, when you are proving a contract in a civil court, you have to know what is the digital signature and how to prove the digital signature and how to establish a digital signature. There will be public key, private key antare. What is the public key? What is the private key? Andaga, generally our mind goes back to the key like this, but it is not a key like this. It is something else. When actually that key is put into operation, in the hash number barutte. That hash number is a unique number, and when you are going to have to prove it in a court of law, then you have to invoke Order 26 Rule 10A. That's why I am telling you. See, why should you invoke Order 26 Rule 10A in a scientific age? Is this because you are going to be faced with the problems of modern nuances are concerned. And ಹಳೆಯ ಕಾಲದಲ್ಲಿ ನಾನು ರುಜುವು ಮಾಡೋದು ನನ್ನ ಮುಂದೆ ನನ್ನ ಪೆನ್ ಸ್ಟೈಲು, ನನ್ನ ನಿಂತ್ಕೊಳ್ಳೋ ಸ್ಟೈಲು, ನನ್ನ ಮಾನಸಿಕ ಸ್ಟೈಲು, ಇದೆಲ್ಲ ನಾವುಗಳು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ವಿ, ಈಗಲೂ ಮಾಡ್ತೀವಿ ಎಷ್ಟೋ ಕೇಸುಗಳಲ್ಲಿ. ಆದರೆ ಡಿಜಿಟಲ್ ಸಿಗ್ನೇಚರ್ ಯುಗ ಬಂದ ನಂತರ, ಈ ಒಂದು ಕಾಂಟ್ರಾಕ್ಟ್ಸ್, ಕಮರ್ಷಿಯಲ್ ಕಾಂಟ್ರಾಕ್ಟ್ಸ್ ಬಂದ ನಂತರ, ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ನಲ್ಲಿ ನೀವು ಅಪಿಯರ್ ಆಗಬೇಕಾದ್ರೆ ಈ ವಿಷಯಗಳು ಬರುತ್ತೆ. ಸಿ, ದಟ್ಸ್ ವೈ ಐ ಆಮ್ ಟೆಲ್ಲಿಂಗ್ ಯು, ದಿ CPC is to be looked into in a broader spectrum, not with a narrow spectrum. You have to look into it. And provisions have been made under Order 26 Rule 10A to have the signatures of the people having the public and private key. And when you have to do that, you have to know what is a public key, how to prove. Certifying authority ಅಂತ ಇದ್ದಾರೆ, ಆ ಸರ್ಟಿಫೈಯಿಂಗ್ ಅಥಾರಿಟಿಗೆ ನಾವು ಸಮನ್ಸ್ ತಗೋಬೇಕು. ವಾಟ್ ಇಸ್ ದ ಕ್ರೆಡಿಬಿಲಿಟಿ? ಯಾಕಂದರೆ ಪ್ರೊಸೀಜರಲ್ ಲಾ is the one which is going to tell you about the procedure to be adopted in the court. And substantive law is a law which gives you rights and liabilities. Do it, don't do it. That's what substantive law says. But procedural law is the one which says as to how you have to work out your right and remedy. That is where you have to understand the importance of substantive law and procedural law. And therefore, when you are applying these techniques of establishing a fact in a court of law, especially a civil court, while administering the civil justice, you have to get yourself acquainted with this. This is what actually I want to tell you about new nuances of the scientific development about CPC is concerned. And section of, and one more thing I would like to mention to you about the recent amendment to the law which has been made by the Karnataka government, that is known as Act number 2 and 3 of 2024 is concerned. What is this Act number 8 of 20, not 2 and 3, Act number 8. Act number 8 of 2024 is the most important thing. Act number 8 of 2024, I hope some of you have gone through this legislation. This is known as Code of Civil Procedure Karnataka Amendment 2023. It shall extend to whole of Karnataka. It shall come into force from the day it has been notified, already has been notified. And under this, Order 17 of the Civil Procedure Code has been amended. Under Order 17 of the Code of Civil Procedure is amended. What is Order 17 of Civil Procedure Code? Generally we say it is a thing which deals with adjournments, and it is where actually the things relating to the day in and day out, we file an application under Order 17, and Order 17 is the most important tool which we use for the purpose of the judicial process in civil court. Adjournments. Order 17 speaks about adjournments. Adjournments ಬಗ್ಗೆ ಇರುವಂತಹ ಇದರಲ್ಲಿ ಕೆಲವು ಅಮೆಂಡ್ಮೆಂಟ್ಗಳನ್ನು ಮಾಡಿದ್ದಾರೆ. ಮೊದಲಿದ್ದ ಅಡ್ಜರ್ನ್ಮೆಂಟೇ ಬೇರೆ. ಈಗಲೂ ನಾವು ನಮ್ಮ ಸಿವಿಲ್ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಸಿವಿಲ್ ನ್ಯಾಯಾಧೀಶರುಗಳು ಆಗಲಿ, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ನ್ಯಾಯಾಧೀಶರೇ ಆಗಲಿ, irrespective of Order 17, they give adjournments indiscriminately. Why actually this Order 17 was amended? Earlier, ಇವತ್ತು ಸ್ವಲ್ಪ ನಡೆಸೋದು, ಇನ್ನು 6 ತಿಂಗಳಾದ್ಮೇಲೆ ನಡೆಸೋದು, ಇನ್ನೊಂದು 6 ತಿಂಗಳ. ಈ ಸಿವಿಲ್ ಕೇಸುಗಳು ಕೋರ್ಟಿಗೆ ಬಂದರೆ ಈ ಹಲ್ಲಿನ ವ್ಯಾಧಿ ಇದ್ದಂಗೆ. ಈ ಹಲ್ಲಿನ ವ್ಯಾಧಿ ಡಾಕ್ಟರ್ ಹತ್ರ ಹೋಗ್ತಾ ಇರ್ತಾನೆ, ಡೆಂಟಿಸ್ಟ್ ಹತ್ರ. ಎಸ್ಪೆಷಲಿ ವಯಸ್ಸಾದವ್ರಿಗೆ ನಾನು ಹಲ್ಲಿನ ವ್ಯಾಧಿ ಬಗ್ಗೆ ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ, ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಯಂಗ್ಸ್ಟರ್ಸ್. ಯಾಕಂದರೆ ಯಂಗ್ಸ್ಟರ್ಸ್ಗೆ ಹಲ್ಲಿನ ವ್ಯಾಧಿ ಇನ್ನೂ ಬಂದಿರೋದಿಲ್ಲ. ಈ ವಯಸ್ಸಾದವ್ರಿಗೆ ಹಲ್ಲಿನ ವ್ಯಾಧಿಯಿಂದಾಗ ಹಲ್ಲು ನೋವು ಬರುತ್ತೆ, ಹೋಗ್ತಾರೆ. ಇವತ್ತು ಬಾ, ಈ ಹಲ್ಲಾಯಿತು, ನಾಳೆ ಬಾ. ಈ ರೀತಿ ಈ ಹಲ್ಲಿನ 32 ಹಲ್ಲಿಗೂ ವ್ಯಾಧಿ ಇದಾಗೋವಷ್ಟು ಇವನು ಸಮಯ ಪೂರ್ಣ ಕಳೆದುಬಿಟ್ಟಿರ್ತಾನೆ. ಆ ಥರನೇ ಸಿವಿಲ್ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ನಡೆಯೋದು. ಸಿವಿಲ್ ವ್ಯಾಜ್ಯ ಅಂದರೆ ಎಂಡ್ಲೆಸ್. ಇವತ್ತು ಹಾಕ್ತೀವಿ, ದ್ಯಾವನ ಇತ್ಯರ್ಥ ಆಗೋದು ನನ್ನ ಮೊಮ್ಮಕ್ಕಳ ಕಾಲಕ್ಕೆ, ಮರಿಮಕ್ಕಳ ಕಾಲಕ್ಕೆ ಇತ್ಯರ್ಥ ಆದರೆ, ಇಲ್ಲದೇ ಇದ್ದರೆ ಅದೂ ಇಲ್ಲ. ಆ ಒಂದು ಸನ್ನಿವೇಶ. ಎಷ್ಟೋ ಕೇಸುಗಳು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 50 ವರ್ಷದ ಕೇಸುಗಳು ಇನ್ನೂ ಪೆಂಡಿಂಗ್ ಇದೆ, 9 ಕೇಸು 10 ಕೇಸು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ರೀಸೆಂಟ್ ವರದಿಯಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಯಾಕೆ ಹೇಳಿದ್ರೆ ಸಿವಿಲ್ ಕೇಸುಗಳು ಈ ಥರ ಪ್ರೊಲಾಂಗ್ ಆಗೋದು ಜಾಸ್ತಿ. ಈ ಒಂದು ಪ್ರೊಲಾಂಗೇಷನನ್ನು ಅವಾಯ್ಡ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ನ ಅಮೆಂಡ್ ಮಾಡಿದ್ರು. 2002ರಲ್ಲಿ ಮಾಡಿದಂಥ ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ನಲ್ಲಿ ಒಂದು ಸಾತಿ ಟ್ರಯಲ್ ಬಿಗಿನ್ ಆದರೆ ಡೇ ಟು ಡೇ ನಡಿಬೇಕು ಅಂತ. ಯಾರೂ ನಡೆಸೋಲ್ಲ, ನಾವುಗಳು ನಡೆಸೋಲ್ಲ. ವಕೀಲರುಗಳಾಗಿ ನ್ಯಾಯಾಧೀಶರುಗಳು ಅದಕ್ಕೆ ಸರಿಯಾಗಿ ಮಾರನೇ ದಿವಸಕ್ಕೆ ಹಾಕೋಲ್ಲ. ಅದು ದಟ್ಸ್ ವೈ ಐ ಆಮ್ ಟೆಲಿಂಗ್ ದ ಲಾ ಇನ್ ಟೆಕ್ಸ್ಟ್ ಈಸ್ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ಲಾ ಇನ್ ಕಾಂಟೆಕ್ಸ್ಟ್ ಅಂತ. ಲಾ ಇನ್ ಟೆಕ್ಸ್ಟ್ ಏನು ಹೇಳುತ್ತೆ? Once the case has begun, once the trial has begun, the case must go on from day-to-day basis. When does the trial begin? When does a trial begin is the question. See, in a civil case, trial begins when the issues have been framed. When the issues have been framed, the trial begins. What is meant by framing of issues? Framing of issues is governed under 3 important provisions of CPC. One is Section 89. The second one is Order 10, and the third one is Order 14. These are the relevant provisions which have to be borne in mind about the framing of issues. And Order 10 says, examination of parties. None of the court does. And ಎಷ್ಟೋ ಕೇಸುಗಳಲ್ಲಿ ಅದನ್ನು ಮಾಡಿದ್ರೆ ಇತ್ಯರ್ಥನೆ ಮುಗಿದೋಗ್ಬಿಡುತ್ತೆ. ಆದರೆ none of the court does. And even we as advocates, we don't allow. We are also responsible. I am not telling the courts only responsible, and we are also responsible. And but the same thing cannot be adopted by the younger generation. That's what I'm telling you. You as a members of the profession, as a younger generation, please see that the disputes are resolved expeditiously. If you get the dispute resolved expeditiously today, tomorrow you will get one more case. But the days were earlier, it was not like that. ನಾನು ಹೇಳಿದ್ನಲ್ಲ, ಈ ಸತ್ತ ಕರಡಿಯ ಒಂದು ಬಾಲವನ್ನು ತಿರುಗಿಸುವ ಹಾಗೆ ತಿರುಗಿಸ್ತಾ ಇತ್ತು. ನನ್ನ ಮಗನ್ನ ಇಂಗ್ಲೆಂಡ್ಗೆ ಕಳಿಸ್ತಾ ಇದ್ದೆ ಬ್ಯಾರಿಸ್ಟರ್ ಆಗೋದಕ್ಕೆ. ಯಾತಕ್ಕೆಂದರೆ ಈ ಕೇಸಿಂದ ಅನ್ನೋ ಒಂದು ಮೆಂಟ್ಯಾಲಿಟಿ ಇತ್ತು ನಮಗೆ ಆವಾಗ, ಸತ್ತ ಕರಡಿಯ ಬಾಲವನ್ನು ತಿರುಗಿಸೋದು ಅಂತ. ಆದರೆ ಇವಾಗಿನ ಒಂದು ನ್ಯೂ ಜನರೇಷನ್, ಇಟ್ ಈಸ್ ನಾಟ್ ಸೋ. ಯು ಆಸ್ ದಿ ಮೆಂಬರ್ಸ್ ಆಫ್ ದಿ ಯಂಗರ್ ಜನರೇಷನ್ ಹ್ಯಾವ್ ಗಾಟ್ ಎ ಸೋಷಿಯಲ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ and to see that the disputes are resolved expeditiously. When you get the disputes resolved expeditiously, automatically you will get one more case. Oh, this advocate is good, we will take it. See, this is how you have to build up your profession as youngsters. Though I began with the old story and all these things, I started because in order to infuse your interest. See, you must inculcate those things. And now the law has been amended in Order 17, saying that the trial must begin. When once the trial begins, no adjournment should be granted. But still we are not following it, but that's a different issue. But now, I told you, when does the trial begins? Trial begins, Order 10, look at it, framing of the examination of the parties, and go to Order 14, framing of the issues. And what is an issue? Is the next question comes. When it comes, the Order 14 says, a material assertion of one party and denial by the another party gives rise to an issue. And sometimes in a suit for injunction, how many issues are required? Hardly 3 issues or 4 issues. But sometimes we find non-application of mind more than a dozen of issues. See, if court frames issues wrongly, it is your duty as an advocate to bring to the attention of the court, sir, this does not require. Order 14, Rule 5, though the framing of the issues is the responsibility of the court, under Order 14, Rule 5, a responsibility is cast on you, and you can even get the issues amended. That is the thing. Why I am telling this is how the issues are going to lead you in future about the case is concerned. The foundation what you are going to put at the trial stage is the most important thing, which is going to make the building to stand. If your foundation at the trial stage is not proper, then no Supreme Court or no High Court or no Supreme Court can do anything. The case has gone. Therefore, your responsibility as a social shock absorber, as a social engineer, as Raskopon said, is the most important thing. If you read the jurisprudence of Raskopon, he says that every lawyer is a social engineer, and the responsibility of the lawyer is to build up a society which is going to have the edifice of the society in a firm way. Therefore, think that you are not the third-class citizens of the country. Think that you are the first-class citizens of the country. And therefore, I request the younger generation of the bar to bear some of these things and don't have the old concept of ಏನಪ್ಪ ಕೇಸ್ ಹೋಗ್ಬಿಟ್ರು ಇದೇ ಕೇಸೇ ಬರೋದಿಲ್ವೇನೋ ಅನ್ನೋ ಒಂದು ಭಾವನೆ ಇಟ್ಕೋಬೇಡಿ. And Order 17 says that a party can have 3 adjournments. That is 3 for plaintiff, 3 for defendant, and not more than that. But how many cases we have followed this? How many cases we follow this? We don't follow it in a meticulous way. Application of the mind, application of law is not there by the younger generation. Because now you youngsters have been permitted to take the competitive examination as a judicial officer, maybe as a civil judge junior division or maybe as a district judge. Of course, as far as the district judge is concerned, you have to put in 7 years practice. But for a civil judge junior division, you need not put in any practice. You get your name enrolled in the bar council, go and write the examination, and therefore it is for you. Earlier it was not like that. The people has to have put in 4 years of service. During those 4 years of service, as Justice Desai of the Supreme Court observed, sometimes bad habits used to be followed by the juniors. Therefore, in order to put an end, now the Supreme Court and also Law Commission of India has said that actually practice is not required. In fact, the days are there. We are going to have the judges who are judge-oriented and lawyer-oriented law graduates. That is lawyer-oriented law graduates and judge-oriented law graduates. We are going to have that period. Therefore, you must know what type of law you have to apply in a civil court is concerned. And now, Order 17, of course, was the one which was under the consideration in the Karnataka Act. This Karnataka Act says that Order 17 Rule 3, after that, a new rule is to be added, that is known as Order 17 Rule 4. Order 17 Rule 4 contemplates that priority of disposal of cases involving small farmers and persons belonging to economically weaker section. See, this is the law which has been made by the Karnataka legislature, and this is already in force. And I don't know how many of you have read this. In fact, if you have not read this, please read this. This says that where in any suit or other proceeding in any court, small farmer or person belonging to economically weaker section is involved either as plaintiff or defendant, such case shall be taken up on priority over other cases listed for the day. This is what actually, in fact, High Court had issued circulars at one point of time that the cases involving senior citizens must be disposed of expeditiously. But the circular remained as a circular, and it has not. But now the legislature has made a law that this is the law, and hereafterwards you have to find out that the cases must be disposed of expeditiously. Therefore, every court is bound by this law. And for this purpose, when you are appearing for a farmer, or a small farmer, or when you are appearing for a person who belongs to economically weaker section of the society, you have to insist the court, well, Mr. Judge, please take up this matter expeditiously and decide. Otherwise, your client, who is already in a state of penury, or already who is not in a state of responding to the social call as a small farmer, he will not. In fact, I remember one incident as an anecdote once again. ಭೂತಯ್ಯನ ಮಗ ಅಯ್ಯು ಅಂತ ಒಂದು ಕನ್ನಡ ಫಿಲ್ಮ್ ಬಂದಿತ್ತು. ಭೂತಯ್ಯನ ಮಗ ಅಯ್ಯು ಒಳಗೆ, ಐ ಡೋಂಟ್ ನೋ ಮೆನಿ ಆಫ್ ಯು ಹ್ಯಾವ್ ಸೀನ್, ಎಸ್ಪೆಷಲಿ ಯಂಗರ್ ಜನರೇಷನ್ ಮೈಟ್ ನಾಟ್ ಹ್ಯಾವ್ ಸೀನ್, ಓಲ್ಡರ್ ಪೀಪಲ್ ಡೆಫಿನೆಟ್ಲಿ ದೇ ವುಡ್ ಹ್ಯಾವ್ ಸೀನ್ ಇನ್ ರಿಲೀಸ್ಡ್ ಇಟ್. ಅದರೊಳಗೆ ಅವನು ಹೇಳ್ತಾನೆ, ಧರ್ಮಯ್ಯ ಅಂತ ಒಬ್ಬ ಕೋರ್ಟ್ಗೆ ಹೋದವನು ಸೋತವನು ಸತ್ತ ಅಂತ ಒಂದು ಗಾದೆ. ಆ ಥರ ಆಗಬಾರ್ದು. ಯಾಕೆಂದರೆ ಇರೋ ಮನೇನೂ ಕಳ್ಕೊಂಡ್ಬಿಟ್ಟ ಅವನು ಇರೋ ಮನೇನೂ ಕಳ್ಕೊಂಡು ಕೊನೆಗೆ ನೇಣು ಹಾಕೊಂಡು ಸಾಯೋ ಸ್ಥಿತಿಗೆ ಬಂದ್ಬಿಡ್ತು. ಆ ಥರ ಆಗಬಾರ್ದು. ನಿಮ್ಮ ಮೇಲೆ ಒಂದು ಸಾಮಾಜಿಕ ಒಂದು ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಇದೆ. ಆ ಸಾಮಾಜಿಕ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಒಳಗೆ ನೀವು ಯಾರಿಗೆ ಪಿಯರ್ ಆಗ್ತೀರಿ, ನೀವು ಈ ಒಂದು ಕಾನೂನನ್ನು ಜಾರಿಗೆ ತರಬೇಕೋ ಬೇಡವೋ ಅಥವಾ ಅವನಿಗೆ ನ್ಯಾಯ ಕೊಡಿಸ್ಬೇಕು ಅನ್ನೋದನ್ನು ಪರಿಗಣನೆ ಮಾಡಬೇಕು. ಇಟ್ ಸೇಸ್ ದಟ್ ದಿ ಪೀಪಲ್, ದ ಕೋರ್ಟ್ ಶಾಲ್ ಹಿಯರ್ and dispose of such cases as far as possible within 6 months. See, of course, the question do arise. 6 monthsಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಡಿಸ್ಪ್ಯೂಟನ್ನು ಮಾಡುವಂತಾರೆ, ಇನ್ನೊಂದು ಮಾಡುವಂತಾರೆ, ಕನ್ಸ್ಯೂಮರ್ ಫೋರಮನ್ನು ಮಾಡುವಂತಾರೆ. ಹೆಂಗೆ ಮಾಡೋಕ್ಕಾಗುತ್ತೆ ಅಂತ ನ್ಯಾಯಾಧೀಶರು ಹೇಳ್ತಾರೆ. ಆದರೆ ಅದಕ್ಕೆ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಬೇಕು, ನಮಗೆ ಕೊಟ್ಟರೆ ಮಾಡ್ತೀವಿ ಅಂತಾರೆ. ಆದರೆ ಆ್ಯಸ್ ಎ ಅಡ್ವೊಕೇಟ್ ಹ್ಯಾವಿಂಗ್ ಎ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಇನ್ ದಿ ಸೊಸೈಟಿ, what is your contribution? This is what actually I am asking. Therefore, ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರು, ಇವತ್ತಿನ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ಗೂ ಸುಮಾರು ಒಂದು 20 ವರ್ಷದ ಹಿಂದೆ ಇದ್ದಂತಹ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ಗೂ ಕಂಪೇರ್ ಮಾಡಿದ್ರೆ ಇವತ್ತಿನ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸ್ ಆರ್ ಬೆಟರ್ ಪ್ಲೇಸ್ಡ್, both economically and also infrastructure wise. Whereas we had seen the judicial officers taking down the depositions by hand, writing the judgment by hand, and now we see the judicial officers who have been equipped with all technologies, and therefore the plea that we don't have infrastructure is not the concern. What is required is zeal to work is the most important thing. If the zeal to work is not there, and who has to inculcate the zeal to work? It is you who have to inculcate the zeal to work. And if you don't do it, no, everything will be a paper paradise. Therefore, court shall bear and dispose of such cases as far as possible within 6 months. In case pending on the date of commencement of this code, of this act, from such date, commencement of the date fixed for the hearing of the case is concerned, or in case filed after the commencement of the Code of Civil Procedure Amendment Act 2023, from the date fixed in the summons or notice on such proceedings, and is aware. And this is how the entire law has been made. Why this law has been made? It is in order to see that the small farmers and the people who are economically not well placed should not waste their time in the court. Court is not a place to waste their time. It is a place to have their dispute resolved. And on the other hand, what is happening now? The entire court premises is actually filled with these type of people. They forget their work, they forget their earning, and they think that attending the court is a big job for them. Therefore, in order to see this type of things are taken away, the law has been amended. And therefore, I for one would tell the youngsters that please bestow your thought about Order 17 is concerned, as amended, when you are appealing for the small farmers and also economically weaker section. Maybe my talk may not be liked by many, but still I have to tell you this one. And I told you about Order 26, Rule 10A. Why? The days have changed. We are actually in the days of technology. Please make use of these things whereby you can have. And the third thing I would like to know, or I would like to discuss with you, is relating to supplemental proceedings. There is a provision in CPC known as supplemental proceedings. But many a times, the supplemental proceedings have become supplanting proceedings. What is a supplemental proceeding? Which section? Which section of the CPC deals with the supplemental proceedings is the most important thing. Of course, you have utilized the provisions under Order 39, Order 38 relating to attachment, temporary injunctions, and also relating to receivers corresponding in Order 38, 39 and 40 of the Civil Procedure Code. But where from these rules or orders have got a sanction, where from this power has come is the most important thing. When you look at it, you find Section 94 is a corresponding law under CPC which gives the power to have the rules. Therefore, the rules have been framed under Order 38, 39 and 40. Section 94 of the Civil Procedure Code deals with that of supplemental proceedings. It is not supplanting proceedings. Supplanting proceeding is different from that of supplemental proceeding. Supplemental proceeding is only to see that the court is actually helped, and also the parties are going to be helped. There is only a helping stage, and not to remove it. But we are not using it. But we file a suit for injunction, and the suit application for IA is filed. IA is kept pending for years together sometimes. But what the law says, IA must be disposed of within 30 days with reason, and without reason he cannot extend. But unfortunately our courts are extending the time, and IA is filed, injunction order is obtained, and ex parte every time we find a ingenious method of saying that the interim order continued. Interim order continued. Why? An IA and Order 39, Rule 4 is there. That is not considered. But in spite of it, interim order continues. Because for continuing the interim order is very easy. Therefore, why I am telling you is, as youngsters, you must develop this aspect and see that the legal profession is brought back to its normalcy is concerned. Otherwise, now we will feel that the entire society is actually facing a panorama of dwindling. That's why I said in the beginning that Shakespeare said, kill all lawyers if you want to have the disputes resolved. That is not the question. We must have the lawyers in a society who are the shock absorbers, as Rascopont said. Therefore, please read Section 94. We have got to remember one more aspect in Civil Procedure Code, incidental proceedings, which is the section which deals with incidental proceedings, is the most important thing which you have to note. And what are the incidental proceedings which we have to bear in mind, and how incidental proceedings are different from supplemental proceedings? See, now, when you want to have a commissioner appointed, it is an incidental thing. It is not a supplemental thing. A commissioner is appointed under Order 26 in order to see that the court is helped to facilitate that the case is disposed of expeditiously, or opinion is formed by the court expeditiously. Therefore, Order 26 is an incidental proceeding, and whereas the Order 20, Order 39, 38, 40 are the supplemental proceedings. Therefore, as youngsters, please bear in mind there is a difference between supplemental proceedings, incidental proceedings are concerned. And now, one more thing I would like to mention to you about is relating to that of precept. What is a precept? Especially youngsters, I am asking. What is a precept? What is a precept? Which provision of Civil Procedure Code deals with precept? Is the most important thing which you have to know. Precept is dealt with under section 56 of the Civil Procedure Code, and for that you find corresponding rule in Order 21 is concerned. Therefore, precept is different from that of writing letters, and how the precept must be issued. These are the aspects which the youngsters have to bear in mind. See, these are all the aspects which you get only by your consistent effort being put forth. This is what actually I wanted to tell you for this 1 hour. Still now, I have got 1 more hour at my disposal, and I have got to discuss about other aspects of the Civil Procedure Code is concerned. If you look at Civil Procedure Code, one of the biggest problem which we find is the execution. In fact, way back in 1932, the Privy Council judge had said that the real litigation in India starts not with obtaining a decree, but putting the decree into the execution. The real litigation starts there, because it's easy to obtain a decree. Plaintiff has come, and sometimes you are obtaining ex parte decree. It's easy to obtain a decree. But to put the decree into execution, that's where you get the fruits of your decree. Merely having a paper decree is not going to convince me. What I am convinced is the result which I am going to get from the decree. Therefore, execution proceedings is the most important thing. Now, as youngsters, you must bear in mind what are the types of executions we are having in Civil Procedure Code is concerned. We have got simplest way of that relating to the arrest of a person, relating to attachment of movables, attachment of immovables, and also relating to that of arrest, and when a person could be arrested, how a person could be arrested, and how long the salary of a person could be detained, attached. These are all the important things. Nowadays, the things are moving from that of the agriculturist area to technological area. Now, certain properties cannot be attached. Certain properties cannot be attached. What are the properties which cannot be attached? What are the properties which cannot be attached? Section 60 of the Code of Civil Procedure deals with the properties which cannot be attached. Earlier, we used to say agricultural implements cannot be attached. But now, youngsters are trying to eke out their livelihood by using computers. Can you actually attach the computer system of a person and see that he is deprived of? No. Tools of artisan is to be looked into in a different angle. See, tools of artisan, because nowadays you find small computer rooms or centers even in the villages, and in such of those places you have to think of these modern technology and modern things are concerned. And don't think that the people who earn their livelihood through these things are all rich people. There are also people who want to have their livelihood being satisfied. Therefore, while interpreting section 60 of the Civil Procedure Code, you have to have a broader aspect. At one point of time, we used to say that agricultural tools were not attachable. Later on, we have come to a stage of even saying that typewriter of a typist cannot be attached. What I'm saying is all from judgments. Typewriter of a typist cannot be attached. But Nowadays, you don't find typists, you find computer operators. Therefore, your approach must be different. So therefore, as youngsters, please devote your time and see that the law is implemented with a motto of new technology is concerned. Therefore, these are the aspects which you have to. When I said about the attachment thing, when I said about executions, the process of execution is the most important. Sometimes we get the situation of the decree being executed by the deputy commissioner, and then final decree proceedings sometimes we come. Whether these things, that's why I told you, in a partition suit, you fight for about 15 years or 20 years, obtain a preliminary decree. But to have a final decree, again you start fighting. See, this is where actually we are finding the difficulty. See, therefore, please read the judgment of Supreme Court rendered by Chief Justice Bobde. Chief Justice Bobde has said that final decree proceedings must be made as a part of the initial suit which you are going to initiate. But what we are doing now, we obtain the decree and wait for that, and then afterwards move the court, and court is going to issue notice, because the principles of natural justice demands that no one should be condemned unheard of, and therefore issue notice, and that person may avoid it or he may delay it, and ultimately you bring it back. And by the time you execute the decree with its finality, it will be much more than a century. Therefore, it should not be the thing. Therefore, Justice Bobde, as the Chief Justice of India, in the Supreme Court has said that the final decree proceedings must be made as a part of the original decree proceedings is concerned. This is where actually we have to, and this is where we have to think of the new dimensions of law. Otherwise, simply reading CPC as it stood in 1908 is of no use. And that's why I said in the beginning itself what this man is going to speak about CPC, which we know because it is there from 1908. But you have to think in the modern angle. If you think in the modern angle, the existing law is going to help you and see that. Now, with this actually, you have to remember that there is a provision known as counterclaim. Counterclaim provisions are there. I don't know how many of you as youngsters have actually looked into it. In fact, Order 8, Rule 6A to G speaks about the counterclaim. And regarding this counterclaim is concerned, we were not having the provision earlier. We had only set off, but not about the counterclaim. And why I'm telling is, such of those who studied Civil Procedure Code earlier to 1973 and earlier to 1977, and also such of those who studied Civil Procedure Code after 1977, if you bifurcate, those people who studied CPC prior to 1977 did not had occasion to study anything about counterclaim is concerned, because there was no provision in CPC. But in 1977, the provision has been made that the counterclaim has been recognized. When the counterclaim is there, when do you raise the counterclaim? And how do you raise the counterclaim? And whether the counterclaim, can you raise it time barred? These are all the questions which do come up. I find in many cases that the parties will not be knowing anything about the counterclaim, and even the advocates do not educate them. That's where actually I'm telling you, please read about Order 8 Rule 6A to Order 8 6G is concerned. When a counterclaim is presented, then the defendant has to pay the court fee. First thing, defendant has to pay the court fee. Second thing is, the defendant, when he raises the counterclaim, the plaintiff will be the plaintiff will have an opportunity of filing the written statement. The plaintiff will have an opportunity of filing the written statement. Therefore, that counterclaim. And second thing is, even in the trial, the counterclaim must be tried separately along with the main claim. Though the plaintiff withdraws, the counterclaim subsists. That is where you have to remember about the counterclaim is concerned. And each of these counterclaims are concerned. Can you raise the counterclaim which is beyond the pecuniary jurisdiction of a case? Because every court has got pecuniary jurisdiction. Every court has got territorial jurisdiction, which you are going to study, or we have studied already as a part of section 16 to 20 of Civil Procedure Code is concerned. And there actually you will find that the counterclaim, how it has to be. And you cannot raise a counterclaim which ought to be filed in a higher court or which is beyond the pecuniary limits of the court is concerned. Therefore, counterclaim is the most important thing which youngsters have to bear in mind while studying Order 8, Rule 6A to G is concerned. Counterclaim is the most important. Therefore, please note some of these things, not that I am saying you are not doing. In fact, many of you are doing, and especially such of those people who are facing the competitive examinations for the judicial service. Keeping them in mind, I am telling them, not the others. Because they are the people who because the question would be asked in the examination, what is a counterclaim? Or counterclaim is preferred under Order 8, Rule 4. No. Order 8, Rule 6A, counterclaim is raised. And Order 8, Rule 9 says, no pleadings subsequent to the written statement shall be entertained. No pleading subsequent to written statement shall be entertained otherwise than the counterclaim is concerned. That is what Order 8, Rule 9 speaks. And we have got a practice nowadays of filing rejoinder. Where is the provision for rejoinder? There is no provision for filing rejoinder in a civil case. And that type of filing rejoinder or the sub-rejoinder, they are all the procedures adopted in the writ court. And what is actually adopted in writ court is not adoptable in the Civil Procedure Code is concerned. That's why I am telling you the practice of filing rejoinder, sub-rejoinder, sur-rejoinder, all these things are totally foreign to the CPC is concerned. Because Order 8, Rule 9 CPC clearly envisages that subsequent to filing of the written statement, no pleadings is entertained. Now the question comes, what is a pleading? What is a pleading? When we speak about the pleading, Order 6, Rule 1 gives the definition of pleading. Pleading means plain intent written statement. And not your objections, not your IAs. Some people have got a tendency of filing. Okay. Some people, President of the bar, I think, he has said, we must give time for having a cup of tea for all of you, including me, so that we will have rejuvenated environment is concerned. So we will have a cup of tea and come. Okay.
David.
Under Order 6, Rule 1 of the Civil Procedure Code. Order 6, Rule 1 envisages that pleading means plain and written statement. Especially the younger members of the bar who intend to have these competitive examinations either in judicial service or in the Department of Prosecution or much less the Indian Administrative Service is concerned. Please note that the pleadings is defined in Order 6, Rule 1 of the Code of Civil Procedure is concerned.
Order 6 Rule 1 envisages that pleading means plain and written statement and nothing else. Therefore, they may give some questions to you in order to trap you, saying that pleading includes rejoinder. Do you agree? No, you should say. So therefore, you must remember these things. And second thing is, how a pleading must be there is the most important thing. Can we write pleading as we like? Or can we have to follow certain principles in writing pleading? And in this context, Order 7 of the Order 6 of the Civil Procedure Code gives clear indication as to what generally pleadings must contain. Pleading must be relating to the facts. Please note, pleading must be relating to the facts and not for evidence and not for arguments. Many a times, while drafting the pleading, maybe a plaint or a written statement, the care is taken to put forth the evidence. No. What is required under Order 6 Civil Procedure Code is that the pleading must be relating to the facts of the case. What fact you have pleaded, you have to prove it. A fact pleaded, if it is not proved, then you are not entitled to a degree. A fact not pleaded, but you are going to prove, you are not entitled to a degree. Therefore, what you have to plead is the most important thing under Order 6. When there is an element of fraud is alleged, then details of fraud must be given in the pleading correctly. And this is where you get Order 6 Rule 4 of the Civil Procedure Code. Civil Procedure Code contemplates if there is an element of fraud, coercion, undue influence, threat, those things must be pleaded properly, and regarding which you have to plead the evidence. See, this is where you have to bear in mind as youngsters the art of drafting and how actually the plaint must be drafted. It is not a matter, you have to draft the plaint only in English. ಕನ್ನಡದಲ್ಲೂ ಬರೀಬೋದು, ಆದರೆ ಸರಿಯಾದಂತಹ ರೀತಿಯಲ್ಲಿ ಬರೀಬೇಕು. ಪ್ಲೀಡಿಂಗ್ನಲ್ಲಿ ಪ್ಲೇಂಟಲ್ಲಿ ಪ್ಲೀಡಿಂಗ್ ಆ್ಯಂಡ್ ಇನ್ನೊಂದು ಪ್ಲೀಡಿಂಗಲ್ಲಿ ತಪ್ಪು ಆಗಿತ್ತು, ಅದನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಬಹುದಾ? Order 6 Rule 17 envisages the provision to get the pleadings corrected. In fact, one of the earliest work of Brihaspati Smriti said, Kevalam Shastram Ashritya Nakartavyam hi Nirnayam Yukta Hina Vichareto Prajahani Jayate. That is, don't go by litera scripta, especially for the procedural law. I am telling you, ಈ ಪ್ರೊಸೀಜರಲ್ ಲಾ ಇದು ಮಾಡುವಾಗ ಡೋಂಟ್ ಗೋ ಬೈ ಲೆಟರಾ ಸ್ಕ್ರಿಪ್ಟಾ, ಗೋ ಬೈ ಯುವರ್ ವಿವೇಕ. ದಟ್ಸ್ ವೈ ಯುಕ್ತಹಾನಿ ವಿಚಾರೇತು ಪ್ರಜಾಹಾನಿತು ಜಾಯತೆ. ದಟ್ಸ್ ವಾಟ್ ಬೃಹಸ್ಪತಿ ಹ್ಯಾಡ್ ಸೆಡ್. Justice Krishna Iyer, in one of the recent judgments, of course not recent, one of his judgments had said that the procedural law is only a handmaid and not a mistress. Therefore, please bear in mind while drafting the pleading, put forth the pleadings properly. Whether you are appearing for the plaintiff or whether you are appearing for the defendant, put forth it properly, because that is the foundation on which the proper building is going to be built in future. And in respect of suits, you have got different types of suits. Money suits, recovery of money, recovery of rent, and recovery of possession, and declaration of title. All these, there are various types of suits. You cannot have cut and paste philosophy. Nowadays, the youngsters are developing a habit. All right, my friend had drafted a plaint like this, let me also draft a plaint like this only. No. Apply your mind, draw the pleadings properly, by application of mind is concerned, and don't have cut and paste philosophy is concerned. This cut and paste philosophy, no doubt, it minimizes the work, but it is most dangerous aspect as far as the field of law is concerned. Therefore, have the thing. And now, I told you pleading must have facts, but pleading must not have the evidence or arguments. If some mistake has done, then I told you that the pleading could be got amended by filing an application under Order 6, Rule 17, Civil Procedure. Can you file an amendment petition as and when you like? Or is there any time limit for filing the application? Is the most important thing which you have to bear in mind. And sometimes the amendment applications are filed at the time of argument. And is it permissible? And what is the consequence of filing the amendment application is the next aspect. Now, the framers of law have made it clear that if you want to file an amendment application, unless you satisfy the court, you cannot file an amendment application when once the trial has begun. That is the most important thing which you have to bear in mind. Therefore, while considering pleading, can you make scandalous assertions or averments in the pleading? ಒಬ್ಬರಿಗೆ ಮಾನನಷ್ಟವಾದಂತಹ ಹೇಳಿಕೆಗಳನ್ನು ಪ್ಲೀಡಿಂಗಲ್ಲಿ ಬೇಕಾಗಿಲ್ಲದೆ ಇರೋ ವಿಷಯಗಳನ್ನು ಹೇಳಬಹುದಾ? ನೋ. The court has got power to strike down such part of things. Unfortunately, we are not doing it. This is what actually we find. That's why it said law in text and law in context is different. And now, when you find an application, you file an application under Order 6 Rule 17 to amend the pleading, then court allows the pleading. When should you amend the pleading? Can you amend the pleading as and when you like? Or do you have to require to amend the pleading within a specific time? Is the most important thing. Order 6, Rule 18 of the Civil Procedure Code contemplates that you must amend the pleading within 14 days from the date of order. That is the most important thing. If you don't do it, then the amendment has lost its value. Therefore, as youngsters, please note each of these steps are concerned. The amendment of pleading could be filed in order to bring home the pleadings compactly, but when once the trial has started, the pleading should not be allowed unless the court permits. And the second thing is that when once the permission to amend the pleading is granted, you must amend the pleading within 14 days from the date of the order is concerned. If you don't amend the pleading within 14 days from the date of order, then the effect of that order would be lost. That is the thing. And if any scandalous averments or unwanted averments are made in the proceedings, then you can file an application to get those things struck off from the pleadings are concerned. This is where actually Order 6 is a most important thing which you have to bear in mind relating to what a pleading is and how the pleading must be. And next one is about Order 7. And Order 7 contemplates about the manner in which the plaint must be drafted, how the plaint must be drafted. And you cannot draft a plaint as you like, and you have to follow certain things. Name of the cause title of the court, party's name, and your case in brief, in a paragraph manner, and then you have to say about jurisdiction of the court, whether this court has got the jurisdiction or not. When you speak about the jurisdiction of the court, you have to bear in mind there are two types of jurisdiction. One is known as territorial jurisdiction, and the other one is known as pecuniary jurisdiction. Territorial jurisdiction is a jurisdiction which speaks about the territory within which the court has got the authority to exercise. I cannot file a case in Bagalkot in respect of my immovable property, which is exclusively situated in Bangalore. I have to file a case in Bagalkot, but there are certain cases where I have got property both at Bagalkot, Bangalore and Chennai, then I can choose any one of those places in the partition suit is concerned. In a suit for specific performance, you have to go and file a suit where the property is situated. See, this is where actually you have to understand about the territorial jurisdiction. Territorial jurisdiction is one which is concerned with the territory of the court. Each court has got a definite territory, and beyond that territory, the court has no power is concerned. And therefore, while instituting a suit, ದಾವೆಯನ್ನು ಹಾಕಬೇಕಾದ್ರೆ ಆ ಒಂದು ಪ್ರಾದೇಶಿಕ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಇದೆಯಾ ಅನ್ನೋದನ್ನು ನೀವು ನೋಡಬೇಕು. ಪ್ರಾದೇಶಿಕ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಇದ್ದರೆ ಅಥವಾ ಪ್ರಾದೇಶಿಕ ವ್ಯಾಪ್ತಿಯ ಎಕ್ಸೆಂಪ್ಷನ್ಸ್ನಲ್ಲಿ ಬಂದರೆ ಆವಾಗ ನೀವು ದಾವ ಹಾಕ್ಬೋದು, ಇಲ್ಲದೆ ದಾವ ಹಾಕೋಕ್ಕಾಗೋದಿಲ್ಲ. ಇನ್ನೊಂದು ಪೆಕ್ಯುನರಿ ಜುರಿಡಿಕ್ಷನ್. ಪ್ರತಿಯೊಂದು ನ್ಯಾಯಾಲಯಕ್ಕೂ ಅಂದರೆ ಟ್ರಯಲ್ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಒಂದು ಆರ್ಥಿಕ ಮಿತಿ ಇದೆ. ಆ ಪೆಕ್ಯುನರಿ ಲಿಮಿಟ್ಸ್ ಒಳಗೆ ಹಾಕ್ಬೋದು. ರೀಸೆಂಟ್ಲಿ ಅಫ್ಕೋರ್ಸ್ ಕರ್ನಾಟಕ ಗೌರ್ಮೆಂಟ್ the Karnataka state has amended the Civil Courts Act, and they have increased the limits of the civil judge junior division is concerned. Therefore, you must know what is the pecuniary limit of the court where you are going to institute, and therefore you have to have the thing in the pecuniary aspect is concerned. Therefore, in the plaint, while drafting, I was telling you about drafting of the plaint. While drafting the plaint, first thing you have to mention the cause title, name of the parties, and some people have got a habit of saying Rama Major. Rama ಅವನು ಕ್ಲೈಮ್ ಟು ರಾಮ, ಅವನ ವಯಸ್ಸು ಇವನಿಗೆ ಗೊತ್ತಿಲ್ಲ, ಮೇಜರ್ ಅಂತ ಬರ್ಬಿಡೋದು ತಪ್ಪದು. ಅವನ ವಯಸ್ಸು ಎಷ್ಟು ಬರೀಬೇಕು, ಗೊತ್ತಿಲ್ಲದೆ ಇದ್ದರೆ ವಿರುದ್ಧ ಪಾರ್ಟಿಯವರಾದರೆ ನೀವು ಹೇಳ್ಬೋದು ಗೊತ್ತಿಲ್ಲ ಅಂತ. ಪಕ್ಷಗಾರ ಅವನೇನೆ, ನನ್ನ ವಯಸ್ಸು ಎಷ್ಟು ಅಂದರೆ ಮೇಜರ್ ಅಂದ್ಬಿಟ್ಟು ಅದು ತಪ್ಪದು. ಆದ್ದರಿಂದ ಕರೆಕ್ಟಾಗಿ ನೀವು ಪ್ಲೇನ್ನಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಬರೆಯುವಾಗ ಕರೆಕ್ಟಾಗಿ ಬರೀಬೇಕು. ಇದು ಮುಖ್ಯವಾದದ್ದು. ಹೌ ದ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಮಸ್ಟ್ ಬಿ. ಆ್ಯಂಡ್ ದೆನ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ನಲ್ಲಿ ಆದ ನಂತರ ಅಂಡರ್ ವಾಟ್ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಯು ಫೈಲ್ ದಿ ಪ್ಲೇಂಟ್. Generally we mention that Order 7 Rule 1, but what is the source of power? Again I am going to Oliver Cromwell. What is the source of your power? Section 26 of the Civil Procedure Code. Many people, they don't even mention that the suit is filed under Section 26 read with Order 7. Order 7 is only a procedural aspect, because if you look at the CPC speaks about prescribed under Section 2 of the Civil Procedure Code. What is meant by prescribed? Prescribed means what is prescribed in the CPC under the rules are concerned. Therefore, Order 7 speaks only about the prescription, but whereas Section 26 deals with the power of the court. Therefore, when you are filing a plaint in a court, you must say that the plaint is filed under Section 26 read with Order 7 of the Civil Procedure Code is concerned. If it is a case relating to monetary claim, you have to mention the monetary claim, what is the thing. And if it is in respect of a case where actually it is immovable property, then you have to give the description of the property. Schedule, you must give the details of the property. Please look at Order 7 Rule 1. It speaks about when you are claiming interest, how much interest you are claiming, that also to be mentioned, especially in a commercial suit, which I am now going to the another area of Order 7 with reference to commercial suit. You are claiming interest, and when you are claiming interest on any claim, then you must say under what contract you have the right to claim interest. If there is a contract, then under that contract you must say under this contract I have got a right to claim interest at the rate of 12%. Or if you say no, I am actually relying on Section 34 of the Civil Procedure Code, then you must say that the interest is claimed not under the contract but under Section 34 of the Civil Procedure Code is concerned, because it's a commercial transaction. But if there is no contract you are not claiming under the Section 34 of the CPC is concerned. But there is one more act known as Interest Act. There is no act known as Interest Act. Under the Interest Act, you can claim the interest. Under what circumstances you can claim the interest under Interest Act? For a commercial transaction. Therefore, while drafting the plaint in a civil suit or while drafting the plaint in a commercial court, I hope Bagalkot has got a commercial court. That's what I'm telling you. While drafting the plaint in a commercial court, you must have the bearing in mind under how you have to draft your plaint. And if you draft the plaint in a commercial court as if you are drafting the plaint in a civil court, then your plaint is defective. You will not get the remedy. Therefore, please bear in mind while drafting the plaint, whether you are drafting the plaint in respect of commercial court or you are drafting the plaint in respect of an ordinary civil court, which is not a commercial court, is the most important thing which you have to bear in mind. And now, after having said so, you have to say about the limitation. See, plaint must contain a para relating to limitation also, whether your suit is barred by time. Section 4 of the Limitation Act contemplates that no court shall entertain a suit or appeal if it is barred by time. But Section 5 says that the court can condone the delay in filing the appeal is concerned, but condonation of delay in respect of filing of the suit is not there. Therefore, whether you are actually within the limitation period or not is to be explained. Sometimes what happens, there will be moratoriums or there will be some other proceedings under which you can get the camouflage or you can get the help. So in such a situation, you are invoking Section 14 of the Limitation Act. When you are invoking Section 14 of the Limitation Act, you have mentioned the plaint. For this purpose, I am invoking Section 14, and therefore, my claim is not barred by time. Therefore, what the plaint must contain, I told you from the beginning, once again, to repeat, cause title, name of the parties, and provision of law, then the facts of the case in brief, in a paragraphed manner. Then comes the territorial or the pecuniary jurisdiction of the court. And after having said so, you must speak about the limitation is concerned. With this, the plaint drafting is not over. Plaint drafting, you have to pay court fee. See, what court fee you are paying is the most important thing. And under what law you are paying the court fee. If it is suit for declaration of title of an agricultural land, then you are going to invoke Section 7 of the Court Fee Act is concerned. And if you are seeking declaration in respect of a house, how the market value is going to be determined, that you have to mention. And therefore, you have to speak about the court fee which you are going to pay. And after having said so, you have to file even a valuation slip along with the plaint is concerned. And then, after having done all these exercises, what is the relief you want? See, I may go and stand before the Almaty Dam with a bucket of water. With a bucket, water will not come and fill into my bucket. I have to dip the bucket in the Almaty Dam to lift the water. Then only I will get the water. Likewise, merely filing all these things is not sufficient. What is the relief you want? You have to say. And therefore, plaint must contain all these information. If the plaint is not properly presented in a proper court, then what will happen? You have got provision under Order 7, Rule 10, Civil Procedure Code, dealing with that of the return of the plaint. Plaint could be returned by the court. And there is a provision known as return of the plaint under Order 7. And where the case is presented in an improper court, the court can say, well, I have no jurisdiction, take back the plaint and present it in a proper court is concerned. Secondly, you can also say that the plaint is presented with certain defects. Therefore, the plaint could be represented after complying with the defect is concerned. Therefore, under Order 7, Rule 10, the provisions are there relating to presentation of the plaint is concerned. Now, we come to the next aspect, that is Order 7, Rule 11. Order 7, Rule 11 speaks about rejection of the plaint. Plaint could be rejected by the court under certain circumstances. And what are those circumstances? If the suit does not show the cause of action. Well, that's why I told you, while drafting the plaint, you must bear in mind to say when did the cause of action arose and where did the cause of action arose. Therefore, if the cause of action aspect is not mentioned in the plaint, then the suit could be rejected for not mentioning. Where the suit is barred by another law. For example, let us take a situation of a dispute under the Public Premises Act. There it says, no civil court shall entertain the suit. So there is a bar. So if the plaint could be rejected under Order 7, Rule 11B for the want of the cause of action, want of the bar by the court, bar by the other law is concerned. And thirdly, the plaint could be rejected if insufficient stamp court fee is paid. See, you are bound to pay certain court fee. If you don't pay court fee properly, court will call upon you to pay the court fee. In spite of it, if you don't pay the court fee, court can reject your plaint. So, rejection of the plaint is the most important thing under Order 7 is concerned. Now, after having said all these things, you must remember one more aspect, that decree. What is a decree? What is a decree? Of course, I will come to decree a little later. Now, let me not worry about the decree. Because why I mentioned about decree is, rejection of the plaint is a deemed decree. Please note, rejection of the plaint is a deemed decree. But whereas the return of the plaint is not a decree. That's why I wanted to tell you about this aspect about decree is concerned. But what is a decree? How a decree is different from order, and when the decree is going to be drawn, I'm going to discuss at a later stage is concerned. Now, coming to the written statement, what a written statement should contain. And the written statement must contain the averments which have been specifically denied. ಪ್ಲೇಂಟಲ್ಲಿ ಏನನ್ನು ಹೇಳಿರ್ತಾರೋ ಅದನ್ನ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಡಿನೈ ಮಾಡಿರಬೇಕು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟಲ್ಲಿ. ಮೊದಲನೇ ನಿಯಮ, ಇಫ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಡ್ ಇನ್ ದಿ ಪ್ಲೇಂಟ್ ಈಸ್ ನಾಟ್ ಸ್ಪೆಸಿಫಿಕಲಿ ಡಿನೈಡ್, it is deemed to have been admitted. It is where actually Order 8, Rule 5 comes. And one more thing I wanted to mention to you, of course going back to plaint. Along with the plaint, the plaintiff is supposed to file all the documents on which he is relying. The plaintiff is supposed to file. But whether the defendant is supposed to file all the documents on which the defendant is relying? No. Of course, under Order 8, Rule 3, there was a provision made by the Parliament, but later on the Parliament has deleted that provision. Therefore, defendant need not file all the relevant documents on which he is relying the defense. But the plaintiff has to file all the documents on which the plaintiff is relying. That's the most important thing which you have to bear in mind. And now, written statement is concerned. Written statement must be clear, paragraphed, and also must envisage that the plaintiff's allegations are specifically admitted or denied. And therefore, under Order 8, Rule 5, if you don't deny the averment made by the plaintiff, then it is deemed to have been admitted. Then comes Order 8, Rule 6. which I have told you already about set off and counterclaim. And then comes order 9. If the written statement is not filed, order 8, rule 8 and order 9. And if the written statement is not filed, then the averment of the plaint is deemed to have been admitted. But whether the plaintiff is entitled to a decree? No, because the plaintiff has to prove the case. That is the most thing. And now, order 8, rule 9, I have told you already, no subsequent pleadings could be filed after the written statement is concerned. Therefore, this is where actually we have spoken about order 8 is concerned. Now, when a plaint is filed, what the court has to do? If the next question comes up, of course, written statement dealt with. Now, court will issue summons to the opposite side. And how the summons are being served, that is being discussed under order 5 of the Civil Procedure Code. And Civil Procedure Code contemplates that the summons are to be served on any of the male, earlier it was male members, but now the male members provision has been deleted. Therefore, on any of the adult member of the family, the summons could be served. When once the summons, where the summons has to be served, if a person is working in a government office, then through the proper channel it has to be served. And this is where actually summons are going to be served. And if the summons when it's been served, we have got to remember there are different methods. Summons in a civil court are served only through process department or through Nazar, not through police. In a criminal case, all summons or warrants are to be served through police. But whereas in a civil court, you do not actually take the assistance of a policeman to serve the summons. You have got a separate department in the court known as process branch. And that process branch has got its own organization, and through them only it has to be served. And while serving summons, what are the care which you have to take into consideration is the most important thing. The court has to send plain copy. The defendant must be given summons in duplicate, and plaint must be given, a copy of the plaint must be given, and then only it is proper service. If the summons are served without duplicate copy, it is not a service of summons at all. And if the summons are served without plain copy, it is not a proper service at all, because from the date of service of summons, the written statement is to be filed within 30 days. An obligation is there on the defendant. Therefore, the obligation is cast to see that the plain copy is given, or document of the plaintiff must be given to the defendant. We have got another mode known as the service of summons through registered post, wherein you are actually invoking the provision under Order 5, Rule 20. Of course, in Karnataka we have made simultaneous service also. And therefore, you can send the summons through registered post to the party is concerned. And when once the registered post is there, then service is there, then it owns the service of summons. And now, as far as the commercial courts are concerned, please bear in mind, you have got provision not only through registered post and personal service, but also by email. Because many of these commercial organizations, they have got email facility, and therefore the court can send the summons, generate the summons, and send it by email to the other parties, defendant is concerned. Therefore, in commercial courts, you have got this provision. Besides this, we have also got provision to send the summons through courier. The modern days, we are not relying entirely on the post office is concerned. We even take the help of courier agencies. And when once the courier people's name has been settled, can you choose any person? No. The names have been settled. Those through them you can send the summons to the concerned party is concerned. And then we have got substitute service. A person is not found to be there and summons have to be served, then of course, the good old days, we had the practice of beating of the drum. Nowadays, nobody follows beating of the drum is concerned. We have got paper publication, pasting of the summons copy on the prominent place and where the defendant is carrying on the business or where the defendant is residing. In fact, in one particular case, a situation had arisen whether the summons could be pasted on the land where the defendant was carrying on the agricultural operation. The summons was to be served by pasting. The order was passed by the judge, and the process server went to paste the thing. He found it's an agricultural land, and he pasted it on the agricultural land. Is it a proper service? No. You must place it in a proper manner, in a prominent place. The wording used is so that the other person must see and see that he is intimated about this aspect is concerned. Therefore, the pasting of summons, you must be a little careful. And the other one is paper publication. You publish it in newspaper, and what type of newspaper? It must have proper circulation and wide circulation, and where the defendant or the property is situated is the thing. This is where summons are being served. When once the summons are served, if the party does not appear, whether the civil court can issue warrant to the defendant? No. It is not a criminal court. In a criminal court, if the accused is summoned and for service of summons, if the accused does not appear before the criminal court, the magistrate will issue bailable and non-bailable warrant. But whereas in a civil proceedings, no. The court will place him ex parte. In other words, in your absence we are going to conduct the case. But whereas in a criminal case, no. If the accused fails to appear before the court in spite of issue of summons, then warrant would be issued. He would be compelled to come and appear before the court is concerned in a criminal proceedings. But whereas in a civil proceedings, it is not so. Therefore, you must bear in mind, in a civil proceedings, no question of issuing the warrant for the defendant is there. If somebody says, we are going to issue warrant in a civil case, it is only for the witness and not for the defendant is concerned. Because the defendant will be placed ex parte is concerned. And in his absence or in her absence, the plaintiff will conduct the case. And now, when the defendant is placed ex parte, what is the remedy? Can the defendant come and appear before the court on a subsequent date and say, well, sir, or well, madam, I have been prevented to appear on that day, and now I am appearing. Can it be said? Yes. That order of ex parte would be set aside. And for the reasons given by the defendant, the court may condone and may impose on cost and see that the defendant is given an opportunity to file the written statement is concerned. Plaintiff, under law, is to pay the court process fee. In a criminal case, you don't pay process fee. In a criminal case, it is a state. The prosecutor will say, issue summons to accused number 1, accused number 2, and all these things. You are not going to insist for the process fee is concerned, unless it's a private complaint. But whereas in a civil case, it is not so, where the plaintiff has to pay the process fee. If the plaintiff does not pay the process fee, then what will happen? And on the day when the defendant is supposed to appear, the defendant appears, but the plaintiff does not appear. Then what to do? Can the case be adjourned suo moto, or what the court should do? If the next question comes. Order 9 of the Civil Procedure Code contemplates on this aspect. It says that unless the defendant admits the claim of the plaintiff, if the plaintiff remains absent, the suit is to be dismissed. But of course, we are not taking, in the courts, we are not taking such a stringent action of dismissing the case. But if a particular court takes the stringent action of dismissing, nothing wrong. But the thing is this, plaintiff is supposed to be there. That's what I'm telling you. And then, if the defendant remains absent, he would be placed ex parte. And when once the defendant appears and fails to file the written statement, and he is not, but he does not actually remain absent, then in such an event, for having not filed the written statement, the court has to record the evidence, because non-filing of the written statement itself is not a ground to grant a decree is concerned, because he who seeks a decree has to prove the case. Therefore, under the provisions of Evidence Act, under section 100, 101, 102, if I want a decree, I must prove my case. Therefore, I do. When I am proving my case, when the defendant can cross-examine me without filing the written statement, yes, the defendant can cross-examine me without filing the written statement in order to see that the veracity of my statement is correct or not. Then comes actually Order 10. Is one of the provisions where you find actually the situation of examination of parties with reference to the plaint, with reference to written statement, with reference to documents. All these things could be put together by the court, and court may examine the parties. On examination of the parties, if the court finds there is no dispute, then the court may decide the matter. If the court finds there is a dispute, then the court can actually frame the issues. We go to Order 14. Before going to Order 14, we have to remember the provisions under Order 11. I told you about Order 10, about the examination of the parties. Then we go to Order 11. What is this Order 11? Order 11 is the one which speaks about discovery and inspection. Certain documents are in the custody of others, and if those documents come on record, that will clear the situation. No need to go in for trial. So in such of those cases, Order 11 will be invoked. And under Order 11, you discover something which is in the custody of other person. And then you have got interrogations under Order 11. You can put the questions also. How many times you can put the questions? There is also contemplated in Order 11 is concerned. That is why Order 11 is known as discovery and inspection. Many a times you don't do it. That is the unfortunate thing. But as youngsters, please note that you are actually to go in the right direction. And therefore, especially when you are appearing in a commercial court, you can invoke Order 11 and get the documents are concerned. Therefore, Order 11 comes. Of course, Order 12, for the time being, I will not touch, and I will go to Order 13 is concerned. Order 13 is about production of documents are concerned. If there is a delay in production of documents, along with the plaint or the written statement, you can invoke Order 13 and produce the documents. And then Order 14, relating to issues. That is where actually the court will have to apply its judicial mind. For the first time, the court applies its judicial mind. While issuing the summons, court will not the court will not have the application of the judicial mind. While issuing any order of ex parte, court will not have its judicial mind being applied in toto. But while framing issues, the court will have to apply its mind and see that what are the disputes between the parties. A material assertion made by one party and denial by the other party gives rise to issues. When we come to issues, we have got two types of issues. We have to bear in mind. One is known as preliminary issue. On the basis of the preliminary issue, the case could be disposed of. And issues could be broadly classified into two groups. Actually, that is based on the preliminary disposal, where the preliminary issue is framed. Otherwise, the regular issues will be there. We have got to remember the issue in law and issue in fact. What is an issue in fact and what is an issue in law? In fact, if you read the Evidence Act, profusely you find the word issue in fact, for which you have to need the evidence. But issue in law, you don't need the evidence. Issue in law is mainly connected with that of the issues where a material assertion of law in existence, material denial of application of that law in existence will be there. Therefore, you have got issues in law and issues in fact. Some of the issues are preliminary issues. For example, if there is an issue relating to that of the court fee, then that has to be decided as a preliminary issue. That's why I'm telling you, when an issue related to court fee is concerned, under Section 11 of the Karnataka Court Fee Act, it has to be decided as a preliminary issue. And if an issue goes to the root of the matter without going to the other facts are concerned, it could be treated as a preliminary issue. And therefore, issues frame an important role. Then comes Order 16. Order 16 is the one where you are going to call the witnesses and summon the witnesses. How these witnesses have to be summoned. What are the procedure? How you are going to summon the witness are all dealt with in Order 16. And for a witness, you can bring the witness for yourself, and you can also get the summons to the witness under Order 16. And when a witness fails to appear before the court in spite of service of summons, then what is the consequence? Then you can actually issue warrant to the witness. You can see that bailable warrant is issued, you can see that the non-bailable warrant is issued, and also you can see that the witness is arrested. But all these things cannot be resorted when the defendant remains absent in pursuit of the summons is concerned. Therefore, the Order 16 contemplates about that aspect. But what is the power of the court? Whether the court has got the power to issue the warrants, these are being dealt with in Section 28 onwards are concerned. And now, when once some witness is brought, then the question of examination of witness comes. Then we are going to follow Order 18. Order 17 I already mentioned to you about adjournments. I already mentioned to you about adjournments is concerned. And now comes Order 18. Order 18 deals with that of the hearing of the case. And who has to begin the case? Whether the plaintiff or defendant. Who has to bell the cat? Yaru bekkige ganteyannu kattuvaru annonu. Then Order 18 says, he who pleads, generally the plaintiff has to begin the case. Generally the plaintiff has to begin the case unless the defendant has admitted and put forth certain thing. Now, in a case, there are mixed question of law and facts, and also mixed question of issues both on plaintiff and defendant. Then what is the situation? How you are going to deal with this aspect? If there is a situation where there is a mixed question of issues both on plaintiff and defendant, then it is the plaintiff has to begin. But if the issues entirely on the defendant, it is not for the plaintiff to begin. It is for the defendant to begin. The plaintiff can have a right to rebut the evidence. Unfortunately, we don't do that. Many cases, we actually go by a blind method that once the plaintiff has done, then only the defendant will do. And once the defendant does, go it for argument. No. The plaintiff or the person who begins, not the plaintiff, the person who begins the case has got a right to rebut the case also. That is contemplated in Order 18 Rule 4 of the Civil Procedure Code is concerned. And now, after the examination of the witnesses, certain people are not in a position to come to the court on account of ill health. And how you can examine them? You can examine them by taking commission. And can you take commission to examine a witness in a foreign country? That was a big question which was there earlier. But now, Civil Procedure Code has been amended. You can take such type of recourse also. And therefore, you can examine the witness who is in a foreign country either through video conference or having him examined with the help of a commissioner is concerned. This is how actually Order 18 deals elaborately. And then comes Order 19 and 20 is the last thing as far as the trial is concerned. When once the trial is over, we are happy that a judgment will come. When all this drama is over, the curtain falls down and judgment comes out. Well, plaintiff gets the decree. And how the decree is to be, how to get the fruits of the decree. This is being dealt with under Order 21 of the Code of Civil Procedure. I have told you about the mode of executions. One is relating to that of the attachment of properties. When I say about attachment of properties, it may be attachment of movable property or attachment of immovable property. Attachment of salary is concerned. And then arrest is the next thing. And after attachment, you are going to bring the property for sale, and attachment and sale of the property. Then go to the arrest. In spite of this, a person is very adamant, you can have him arrested. And till the judgment of Supreme Court, as given by Justice Krishna Iyer in Syrian Catholic Bank case, the situation was a judgment debtor could be arrested at any point when once he pleads, does not pay the amount is concerned. But in Syrian Catholic case, the Supreme Court said, well, he can plead no means. And if he pleads no means, the inquiry is to be done. So therefore, bear in mind, while getting the person arrested, the judgment of Supreme Court as given in Syrian Catholic Bank case, as rendered by Justice Krishna Iyer is concerned. Then these are the various methods of having the decree executed. A person who holds a decree is known as a decree holder. A person who is under an obligation under a decree is known as a judgment debtor. That is what the definition says. Can a plaintiff be a judgment debtor? Can a plaintiff be a judgment debtor? I am asking this question especially for the youngsters who are hearing me from almost 1 hour or a little more. Can a plaintiff be a judgment debtor? Yourself? Yes? I am asking you. Yes, sir. Yourself. You turned your face that side. Well, can a plaintiff be a judgment debtor? Don't get nervous. Be calm, comfortable, and even if your answer is wrong, don't worry. Nobody will laugh at you. If your answer is wrong, it's the right direction to go for the right answer. If your answer is right, then I will ask all of them to give a big clap to you.
Case of counterclaim, you can.
In case of counterclaim, let me have from her. Yes, can a plaintiff be a judgment debtor? Yes, madam. So that I will have some time to breathe. Yes. Can the plaintiff be a... Our learned friend said, when there is a counterclaim, then the plaintiff can be a... When there is a counterclaim, the plaintiff, to become judgment debtor, the plaintiff has become a defendant. But my question is, whether the plaintiff can become a judgment debtor. That is my question.
By getting attributed
Huh? No, because he has suffered a decree there. Plaintiff has suffered a decree. See, therefore he gets into the shoe of defendant. Therefore, plaintiff becomes a defendant and suffers a counterclaim. But my question is otherwise. My question is whether the plaintiff can become a judgment debtor. Is a question. I am not talking anything about counterclaim, or I am not talking anything about the other aspects are concerned. I am talking only about plaintiff and defendant. Plaintiff, can he become a judgment debtor? Is my question. And I will answer it. Yes, he can become. When the plaintiff is directed to pay the cost when the plaintiff is directed to pay the cost to the defendant, then defendant is entitled to claim the money from the plaintiff towards the cost. Therefore, the defendant becomes the plaintiff becomes the judgment debtor. Please read the definition of the word judgment debtor is concerned. Let us go back to the section 2, where it defines something about the judgment debtor is concerned. And section 2, clause 10 of the Civil Procedure Code deals with that of judgment debtor. Judgment debtor means any person against whom a decree has been passed. Okay, everyone understood. Or an order capable of being executed is made. Which is an order which is capable of being executed is made. A cost when is imposed on the plaintiff to pay to the defendant, then you can bring an execution against the plaintiff by invoking provision under Order 35 is concerned. 35 is the one where you can actually execute the order. Therefore, plaintiff can become a judgment debtor by reading the definition of the word judgment debtor is concerned. Now, who is a decree holder? Who is a decree holder is the question which comes up for consideration once again. Decree holder is defined in section 2, subsection 3 of the Civil Procedure Code. It defines that decree holder means any person in whose favor a decree has been made or order capable of execution is made. Therefore, even a defendant can become a decree holder, a plaintiff can become a judgment debtor is concerned. Therefore, have this in mind when you are defining the word judgment debtor or when you are defining the word decree holder is concerned. Don't go by the word one who holds the decree is a decree holder, one who suffers a decree is a judgment debtor. If he suffers an obligation under that particular order, then he will become the judgment debtor. And when he gains certain right under that order, he will become the decree holder is concerned. This is where actually you have to bear in mind about the decree holder is concerned. Now, I don't know whether I'm exceeding my time, and all of you may be feeling hungry for the next thing is concerned. And I'll try to wind up within 10 minutes because if I'm asked to talk, I'll be talking endless. If you make me to stop, then I can stop. Otherwise, I'll be talking endless. Therefore, you have to bear in mind about these aspects are concerned. Now, I told you about the decree holder and judgment debtor. What is a decree? What is a decree? Is the next question which comes up for consideration, especially in the minds of youngsters, because I am addressing more for youngsters. What is a decree? Whether decree is defined in Civil Procedure Code. We use day in and day out different types of words like decree, order, judgment, and so on. What is a decree? Has it been defined? The next question comes up. Please look at the definition clause relating to decree. Section 2, clause 2 of the CPC defines what a decree is. Decree means what is a decree is actually defined in section 2 to the effect that I'll read for your benefit. Decree means a formal expression of adjudication, which so far as regards the court expressing it, conclusively determines. So, it's a formal expression of adjudication as far as the court expressing it. it is a conclusively deciding. And the controversy is concerned. And decree could be broadly classified into two groups. One is known as final decree, and the other one is known as preliminary decree. A decree could be classified into, and how many decrees could be there in a suit? How many decrees in a suit? There may be any number of preliminary decrees, but there cannot be final decrees. Final decree is only one is concerned. Now, we have got to remember another concept known as decree is an adjudication of the court as far as the controversy is concerned. Now, we have got a deemed decree. What is a deemed decree? Though it is not a decree, but it is considered as a decree. When does it come? Order 7, Rule 11 speaks about rejection of the plaint. When there is a rejection of the plaint, an order is there, then that order is considered as a deemed decree. An order passed under Order 7, Rule 11, then it becomes a deemed decree. And there are certain provisions in Civil Procedure Code which says that the dismissal of a suit for abatement is a decree, and dismissal of appeal as a time barred is a decree. So these are all the decrees which, though they are not specifically defined under Section 2, subsection 2 of the CPC falls under the category of decree is concerned. Order 7, Rule 11, I mentioned to you. Order 21, Rule 98. Order 21, Rule 98. What is Order 21, Rule 98? It is a thing which speaks about the adjudication of rights of the purchaser. See, in execution proceedings, the rights of the purchaser is given, and that order is a decree under Order 21, Rule 98. And then under Order 21, Rule 58. What is the Order 21, Rule 58? It speaks about the objector's right, and that particular thing becomes a decree. All these things, though they are not decrees, but as far as the court is concerned, it conclusively determines the rights of the parties, then it becomes a decree. You understand? This is the most important thing which you have to know about the definition of decree as youngsters. And now, what is the order and what is the decree? Is there any difference between order and decree? Every judgment actually will have a decree, and every order will not have a decree. And what is the difference between order and decree? Whether order has been defined in the specifically in the CPC is the most important thing which you have to bear in mind. And order is concerned, it is specifically defined, and order is a formal expression. And now we have got to remember some of the words like legal representative. Who is a legal representative? Who is a legal representative? Do you mean legal representative is equal to legal hair? Legal representative is not equal to legal hair, but every legal hair will be a legal representative. But every legal representative is not a legal hair is concerned. Therefore, you must bear in mind legal representative is a person who meddles with the property of the deceased person. Who meddles with the property, not who inherits the property. If a person inherits the property, then he becomes a legal heir. But if he meddles with the property, then he becomes a legal representative. This is the thing which you have to bear in mind. Now, we go on to another definition. What is the mean profit? What is the mean profit? See, I ask some questions sometimes. Not that you don't know. I know you know. But still I ask this question because while you are answering, I will be taking some air to breathe. That's why I'm asking these questions. What is a mean profit? Is it defined in the CPC? Because we use the word mean profit many times. What is the difference between mean profit and interest? Is the question. Mean profit is a profit which a person has gained on account of depriving another person of the property is concerned. Therefore, mean profit is the profit which the other person has derived on account of the deprivation to this person is concerned. Mean profit is specifically defined in the CPC is concerned. Now, with all this definition class, with all this judgment, decree holder, all these things, now I move on to one more provision known as appeal. I have not touched about appeal. If judgment is passed, is there any appeal? If an order is passed, is there any appeal? Yes. Certain orders are appealable. Certain orders are not appealable. So you must bear in mind appealable orders and non-appealable orders. And similarly, decrees are appealable, but certain decrees are not appealable. If the value of the decree is less than a particular amount, or if the decree is passed by consent, then appeal is not maintainable. The appeal is not maintainable under the provisions, under an order passed under special proceedings. The appeal is not maintainable against the decree is concerned. Therefore, you have got to know about the appeal is concerned. In appeal, we have got two types of appeals. One is known as first appeal, and the other one is known as second appeal. First appeal is a question of matter of right, and a person can agitate the first appeal, and there the appellate court will re-look into the matter, both evidentiary aspect and legal aspect is concerned. Scope of the first appellate court is almost similar to that of the trial court, except that of the recording of the evidence is concerned, because already evidence has been recorded. Therefore, the first appellate court has got the jurisdiction to look into the facts and law are concerned. Then, second appeal. As far as second appeal is concerned, in the framework of Civil Procedure Code, all second appeals lies to the High Court, and no second appeal lies to a district court. Of course, in Karnataka we have made a little dent as far as the first appeal is concerned recently, that the first appeal lies to the district court from the order of the civil judge senior division is concerned. But otherwise, the first appeal, if it was above the pecuniary value, it would have gone to the High Court is concerned. But as far as second appeal is concerned, no second appeal comes to the district court or any other court. It goes only to the High Court is concerned. When does a second appeal lies? Is the question. Second appeal lies when there is a substantial question of law involved in the case. This is the most important thing which you have to bear in mind. A second appeal comes only when there is a substantial question of law involved in the case, not otherwise. If there is a question of fact, no second appeal lies. And then, after second appeal, then we have got provision to the Supreme Court by special leave. What is the special leave thing? There it is a substantial question of law involving public interest. See, please note the words. As far as second appeal is concerned, it is a substantial question of law involved in the case. But whereas the appeal to the Supreme Court is concerned, substantial question of law involved in public interest. That is the difference which you have to know. So, one High Court has given one view, the other High Court has given another view. Which High Court has to be followed? The Supreme Court has to decide. There you have got the substantial question of law in the public interest is concerned. Therefore, we have got the appeal provisions. Besides this, we have got two more provisions which I have left till now. One is known as revision, and the other one is review. And these are the two other provisions which you have to bear in mind. Section 115 of the Code of Civil Procedure mainly deals with revision, and 114 deals with that of the review is concerned. Now, with this actually, in fact, I could have explained to you much more about these aspects of review and revision is concerned, but for want of time, because already I have exceeded 6 minutes what had been allotted to me, though we started 1 hour late. I don't want to carry on business to the other person also. So I am going to wind up my discussion at this stage and allow the floor to put any question if you want. Yes, definitely. Yes. There is a provision known as res judicata. What is res judicata? See, of course, when you prompted me about res judicata, I am actually tempted to tell something else also. That is about stay of proceedings, stay of suit. That is section 10 and section 11 of the Civil Procedure Code. Because if you prompt me to talk, I will be talking. If you want me to stop, it's for you to do. So, you have prompted me, so I may take a little more time. Res judicata. Then, section 11 of the Civil Procedure Code speaks about res judicata. Res judicata is a thing which has already been adjudicated by a court of law in India cannot be re-adjudicated by the court once again. It is almost like the principle of double jeopardy in criminal case. In criminal case, we have got a person tried once cannot be retried. This is what actually we have got in criminal law. Similarly, in a civil side, when once the issue has been adjudicated, it cannot be adjudicated once again. It is more based on public policy. In respect of res judicata, you have got constructive res judicata, and sometimes you have got res judicata within the particular case itself is concerned. See, a person has filed an application, and that particular application has been adjudicated. Can another application be filed in the same court regarding the same relief? No. Though it is an interim order is concerned. Therefore, section 11 of the Civil Procedure Code mainly deals with that of the concept of res judicata. Res means a thing. Judicata means adjudicated. A thing which has already been adjudicated cannot be re-adjudicated once again. And there must be finality in the litigation, and that is the public policy also. Therefore, under section 11 of the Civil Procedure Code, a provision is being made that court cannot adjudicate. In fact, if you read section 11 of the Civil Procedure Code is concerned. Let us go back to section 11 for the purpose of our convenience. And section 11 says, res judicata, no court shall try any suit or issue in which the matter has been directly or substantially in issue. Therefore, there must be an issue, and, and that issue has been adjudicated by the court, and when once the court has given the finding relating to that issue, that same issue cannot be re-adjudicated in else other suit is concerned. Res judicata is actually a bar on the court. It is not bar on the parties. Party may put forth all the plea, but the court is actually not to adjudicate it. Therefore, the very opening sentence of section 11 is no court shall. Therefore, it is a mandate on the court not to do it. That is the thing. Now comes to the section 10. What is section 10 of the Civil Procedure Code? Is about stay of suit. If there is a suit pending already regarding the same facts, another suit is brought, then unless the former suit is disposed of, latter suit should not be taken. That is the principle, actually. Therefore, the former suit gets the priority and latter suit gets the place subsequently. Therefore, section 10 says, no court shall proceed with the trial of any suit where the matter in issue is also directly and substantially in issue in previously instituted suit between the same parties. regarding the subject matter is concerned. But whereas in the case of res judicata, no court shall adjudicate the matter where the issue in the earlier case has been adjudicated. But whereas in section 10, it is not the adjudication where there is an issue in the earlier suit, and whether the second suit could be taken. Unless you decide the first case, second case cannot be taken. That is different between the res judicata and stay of suit. In case of res judicata, later suit would be dismissed. Later suit would be dismissed, but whereas in case of stay of suit under order section 10, the later case will not be dismissed, will be kept in abeyance. That is the thing which you have to bear in mind. Therefore, these are the aspects which I wanted to tell you, and I think and I hope I have told you some of these things, and still the floor is open to you. Yes.
Salem Bar Association case 1 and 2. What is the difference?
See, Salem Bar Association case 1 and 2 is the two important things. See, in case number 1, the court appointed a commissioner and also requested the law commission to re-examine, and that judgment of the Supreme Court directing the inquiry to be done or study to be done with reference to Civil Procedure Code, that is Salem Bar Association case number 1. And after the study, the report was submitted to the court. These are all the lacunas which we find. Then the court gave a separate judgment. That is the second judgment of the Salem Bar Association. And based on these two judgments, the Parliament amended the Civil Procedure Code is concerned. That is all the thing. Anything else?
Sir,
Yeah.
you spoke about
Yes. Let us. Section? Oh. What is section 47? Yes. Let us go back to section 47. And because by looking into the papers, I also get some time to breathe. That is the thing. So let us go to section 47. Section 47 says that questions to be determined by the court executing the decree. And all questions arising between the parties to a suit in which the decree has been passed or their representatives and relating to the execution, discharge, satisfaction of decree shall be determined by the court executing the decree and not by a separate suit. So, that court which actually determines whether the decree is executable or not, it has to actually determine. That's why I told you Order 21 Rule 58. What is Order 21 Rule 58? It deals with obstruction. What is Order 21 Rule 98? It deals with that of sale. All these matters must be considered only by that court and not by a separate suit. And there will be a finality. Otherwise, there will be again a order passed in another court and conflict of decisions, and all these things will arise. Therefore, under section 47, provision has been made. Any dispute relating to the executability of a decree is concerned, that has to be determined only by that court and not by the other court is concerned. So, whether the question which you have posed is in respect of the decree, if the court, if you actually say that the executing court had not, if you contend that the court had no jurisdiction to pass the decree, that cannot be passed, that cannot be gone into by the executing court. But if there is a fraud or anything, then that could be gone into by the executing court itself is concerned. Therefore, under section 47, the question relating to the executability of a decree is to be determined only by the executing court and not by the separate suit. You cannot file a separate suit and say that judgment is not binding on me. You understand? Same, if it is between the same parties, then the party cannot say that judgment is not binding on me for these reasons. It has to be gone into by the executing court, and the executing court itself is the competent court to determine the matter under section 47 of the Civil Procedure Code is concerned. I hope I have made myself clear to you. Am I clear? Yes.
Sir, you spoke about Order 7212 when in case of fire,
No.
adjournment is maybe sought by either of the side.
Yes.
If that is the case, is there any provision of law?
Order?
Is there any provision of law in case of inquiry? So as to see that case is adjourned. What is provision of law? In CPC?
Could you kindly repeat your question?
My question is,
Oh.
there is a provision, sir.
Oh.
There is a provision.
Oh.
And Order 1702 of CPC is to say that in case of trial,
Hmm.
case is adjourned by the side.
Oh.
At the same time, is there any provision of law that say that case is adjourned?
Oh.
In case of inquiry, cases, the same inquiry.
See this. Adjournment of a suit applies actually in respect of the inquiry also. There is a provision in Civil Procedure Code which envisages that if, unless it is barred, all the principles of natural justice will apply, and in such an inquiry also the rules of adjournment applies. I will give the judgments also.
So, apply.
Yes, we can apply. No problem.
And what is the case of advancement?
Adjournment.
Advancement of the case.
See, advancement, see, unlike in CRPC, section 311 is concerned, which, where you contemplate about advancement of a case or adjournment of a case is concerned. There is no specific provision in CPC, but case could be advanced in order to meet the ends of justice is concerned, and for that purpose both parties must be given notice and the case is to be advanced by invoking provision under section 151 of the Civil Procedure Code. That's why I said section 151 of CPC is not a restrictive word as used in section 482 of CRPC is concerned.
ಅದರ ಬಗ್ಗೆನೇ ಒಂದು CPC ಕಾಯ್ದೆನ ಪ್ರತ್ಯೇಕ ಪ್ರಾವಿಷನ್ ಮಾಡ್ತಾರೆ ಸ್ಪಷ್ಟ
No, there's no requirement. See, to advance the case.
ಎನ್ಕ್ವೈರ್ಟರ್ದಲ್ಲಿ ಮುಂದಾಗಲಿಕ್ಕೆ ಅದೇ ಪ್ರಕಾರ ಪ್ರಕರಣ ನಿಶ್ಚಿತವಾಗಿ ಪಡ್ಕೊಳ್ಳಿ ಪ್ರತ್ಯೇಕವಾದ ಪ್ರಾವಿಷನ್
ಮಾಡಿಲ್ಲ. ಕರೆಕ್ಟ್. ಪ್ರಾವಿಷನ್ ಮಾಡಿಲ್ಲದೆ ಇರುವ ಕಾರಣ CPC-ನಲ್ಲಿ ಆ ಪವರನ್ನು ತೆಗೆದುಹಾಕಿಲ್ಲ. CPC-ನಲ್ಲಿ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಇನ್ಹರೆಂಟ್ ಪವರ್. CRPC-ನಲ್ಲಿ ಇದೆ ಟು ಅಡ್ವಾನ್ಸ್ ಆ್ಯಂಡ್ ಅಡ್ಜರ್ನ್. ಅದಕ್ಕೆ ಮುಂದಕ್ಕಿದೆ ಇಲ್ಲ. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್?
As you say, law in text and law in
Context are different.
for that one facts of the case. If the landed properties are, the landed properties are, and if the single land, that's the survey number, subdivisions are there. Subdivisions are there. One of the subdivisional, he intended to file a suit for declaration and injunction. Declaration title and injunction. In that suit, if he is not followed the orders, however, that he has not produced any hand sketch map or a description of boundaries.
Yes.
Description of boundaries.
Correct.
Under such circumstances, whether the court can consider that only on the strength of RFR, that is right, or it is necessary for description of the property and the hand sketch map. What is it?
Yes. See, under Order 7 Rule 11, there are provisions relating to rejection of plaint. And does rejection of plaint amount to res judicata? No. See, rejection of plaint is not a res judicata. So, he can file a separate case by complying with the thing what the court has actually found relating to rejection of plaint is concerned. So, plaint could be rejected for certain reasons where actually it does not reveal the cause of action, or where the court fee is not paid sufficiently in spite of time being granted, and where there is a bar of law. Of course, when there is a bar of law, you cannot file a separate suit because law itself bars. In other cases where documents have not been produced and therefore I am rejecting the plaint. See, certain documents are material documents under Civil Procedure Code relating to a titled suit is concerned. Certain documents are not material documents relating to maintainability of the suit. And in such of those cases, the plaint could be rejected. And once the plaint is rejected, a separate suit also could be filed to have the matter relisted in separate number, and then you can go on with the matter. But in the same court, you cannot agitate the matter in the same suit is concerned. That is the thing.
The suit is for declaration of title
Yes.
and injunction.
Yes.
When the property is subdivided,
Yes.
single property is subdivided into many parts.
Yes.
And one of the parties asking, seeking the relief. In such circumstances, whether the R is self-sufficient or a description of the boundary
Yes.
and the handshake map are necessary or not.
Okay. See, rejection of plaint, court has to consider.
I'm not touching the point of rejection.
No, court has to consider only about the averments made in the plaint, not the averments made in the written statement. In the case where you cited, in the written statement, certain averments have been made, and those averments are going to show that the documents have not been produced. Then in such a situation, what is the aspect? Now, as far as this situation is concerned, Order 7, Rule 11 does not apply. Number one, because it is not culled out from the plaint, but you are trying to take out the defense from the written statement is concerned. Therefore, the rejection of plaint does not come. Now the question is, the matter has gone for a trial, and non-production of the document which is in the custody of the party, if it is, then adverse inference will be drawn and judgment will be passed. And as far as that court is concerned, the matter becomes final. It cannot be re-adjudicated except otherwise by way of review, which is a very limited ground, is concerned. Then the only remedy available for such party is to file an appeal under Order 41, and then for non-production of the document by giving reasons, he has to invoke Order 41, Rule 27, and if the court permits, then the document will be taken on record, and the court itself may record the evidence, or on a limited question, the court may send back to give a finding by the trial court on that aspect is concerned. And therefore, on this aspect, I don't find that there is any problem about the situation relating to law in text and law in context is concerned. Because law in text itself provides the remedy under Order 41, Rule 27, that the party who was not able to produce that particular thing can get it produced at the appellate stage under Order 41, Rule 27. But without reasons, he cannot actually show to the appellate court, well, the matter requires a re-adjudication on this aspect is concerned. Yes.
On the same
Okay.
law in...
But don't ask any questions which are pending in the court.
No, no, sir. It's a legitimate only. Law in text and also in context. If the partnership firm intended to file the suit for intended to file the suit, at that time, that plaintiff partnership firm is not producing the partnership deed and also the partners list. Whether he can subsequently file this document.
See, Section 62 of Indian Partnership Act. Section 62 of the Indian Partnership Act says that no suit shall be entertained unless the partnership is registered. So, the maintainability of the suit itself will be subject matter of dispute, not under CPC but under the Partnership Act. So you have to remember there are other laws. See, law is an ocean. Please remember, law is an ocean where you have to have fights of different nature. And in a case of this nature, the suit itself is not maintainable under the Partnership Act, but to claim the relief. But if it is a suit, unregistered partnership, how to have the remedy? That is where you have to have your rights being worked out under substantive law. It's not the procedural law. Anything else? That's all. Thank you very much for the kind patience extended by all of you in spite of my inconveniences of causing